Yes.
Definitely not. For listing of a petition, my lord, on 22nd, my lord. This matter relating to appointment of Kaungura, my lord.
22nd.
The last listed on November 2020. Thereafter, it has not been listed.
For admission.
For admission.
22nd, all right.
May I please, Your Lordship? I recommend item number 20, Lordship. Here, Lordship, Mr. MGC is, his name is reflected in the post list, but nowadays he is living Manipur, Lordship.
Who item?
20.
20.
Yes. He suggests me to file one additional Ukalot Nama, Lordship, so that we can proceed the case.
Okay.
So, allow 1 week time to file one additional.
All right. Item 20 at the request of Mr.
MK New. On behalf of MK New.
MK New, on behalf of Mr. MG Singh, stands adjourned for 2 weeks.
Lordship.
Yes.
May please, Your Lordship. My lord, my vehicle is being sold out tomorrow, Lordship.
What is sold out?
Vehicle, Lordship, personal vehicle.
Ah.
I filed a writ petition yesterday, Lordship. Lordship's matter is urgently required to be considered, Lordship. Lordship, may I pray?
Vehicle is sold out means you've not been able to pay your loan.
Lordship.
Then.
Lordship, already one order is passed by the Honorable Debt Recovery Tribunal to pay the amount of rupees 8 lakhs and take the vehicle. I went to the bank, Punjab National Bank, for depositing that amount, but they refused to accept. As a result, I could not deposit and I could not get the vehicle. And I approached.
Then you have to serve extra advance copy on the bank.
Already I served, Lordship.
All right, tomorrow.
Highly.
May please, Your Lordship. Would you consider back to mention item number 14, Your Lordship? 14.
14.
Can it be taken up on the next week, Your Lordship?
Item 14 at the request of Mr. A. Das, matter stands adjourned for 2 weeks.
Can it be the next week, Your Lordship?
Next week.
And fix 23rd, Your Lordship?
Not 23rd. It will go in the month of December.
The 1st of December, Your Lordship.
5th of December.
I'm led by Mr. K. Chaudhary. He will not be available on 5th, Your Lordship. Can it be on before 5th, Your Lordship? Or he'll be in Supreme Court for the Constitutional Bench, Your Lordship, on 5th of December.
12th? 12th? No.
First, Your Lordship.
No, first, we don't know. First, there are too many matters already.
Or 30th of November, Lord.
All right, 30th.
Much obliged. 30th of November. Obliged, Lord.
May it please, Your Lordship. My lord, may I pray for listing of a writ petition, my lord? Pending matter, admission stage, my lord. First week of December.
All right, first week, you give a mention memo.
Yes, my lord. 4th of December.
Not 4th. Let it be on 6th of December.
6th of December. Highly of that.
May it please, Your Lordship, I beg to mention item number 23 of the daily list. And this matter may be adjourned for the day.
Why?
Lordship, Counsel Mr. S.M. Sarvadrikar is coming from Calcutta, Lordship. He is not well today, Lordship. Can it be on 7th of December, Lordship?
We don't know. We can adjourn it for the day. You have to fix a date later. Item 23 at the request of Mr.
S.A. Borboya.
S.A. Borboya's matter stands adjourned for the day. As it is submitted that the arguing counsel is an outstation counsel who is unable to be present in court today. Yes.
May it please, Your Lordship. I beg to mention one writ petition, Lordship. 48221, Lordship. It was first listed on 25/8, Lordship. Notice was issued returnable.
What do you want?
Only orders, Lordship. Any date next week, Lordship.
December. Take a date in December. 11 December.
Lordship.
For orders.
Orders, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 9, Lordship. I am appearing on behalf of Mr. R. Islam, Lordship. He had informed me telephonically that he had to leave for his hometown, Lordship, as his mother has suddenly fallen ill.
Item 9 at the request of Mr.
A. Chakraborty, Lordship.
A. Chakraborty, matter stands adjourned for 2 weeks.
Lordship, there is an interim order, Lordship.
Interim order, if any, will continue.
Obliged, Lordship.
I beg to mention, my lord, item 18, my lord, that in that case, my lord, there is some typographical mistake in the cost title, in the cost title. So I need to correct it.
Correction is in the name of the parties.
In the name of the party.
Okay.
And their address.
It is submitted by Mr. A. Bhattacharjee that some corrections are required to be made in respect of the name of what?
Petitioner.
Of the petitioners.
Some of the petitioners, there are 15 petitions. Some of the
Names of some of the petitioners. Permission, prayer made is allowed. The corrections be made by filing amended course title in the registry within 1 week from today. Matter will be listed thereafter.
May I please your lordship? Lordship, I am paying for listing one writ petition, which has been pending since 2020. Lordship, kindly fix the
For
date
what?
and
For orders, admission.
for admission, Lord.
List on 13 December.
Obliged.
Yes, Mr. Chauhan.
My lord, with concern of the, my lord, Mr. Counsel of the other side, my lord. And back mention item number 4, my lord. May I come after 2 weeks, my lord.
Item 4 at the request of Mr. S. Chauhan be adjourned for 2 weeks.
Date may be
Counsel
fixed,
for the
lord.
petition respondent is also obtained. Yes. Yes.
Please, Your Lordship. Lord, I am extremely sorry. From today morning, I don't know, I'm having a severe headache.
Oh.
Maybe my power has changed. The other party also has an urgency.
Power of your eyes.
Specs, I think.
You have to be specific.
Yes,
You
but I think
can't say
that's
power
another-
has changed.
Yeah, probably.
Huh.
Because some letters it's difficult now.
All right.
But
all right.
the other party has also an urgency, subject to your lordship's. My lord, if your lordship may kindly take up for this matter for final disposal on 20th of November.
20th is not possible. It has
Then-
to go to December or January. You take a date in January.
Yes, ma'am.
Let it be listed on
Can it be in December, my lord?
huh?
Can it be in the month of December?
December. We can try.
মোৰ আজি ইমান ফোন কৰা নাই ৰাতিপুৱাহে 20 January বিহুৰ পিছত after Bihu, I think 20th January is.
Actually, my lord, Parliament, there is a service dispute between the employer and the employee. And I am appealing for the private respondent because when not in view of the interim order obtained by the petitioner, the order passed by the learned judicial magistrate first class Dibrugarh, there has been halted, my lord. They have granted some monetary leave to us out of the matrimonial.
This is a matrimonial issue.
No,
Service.
but they have obtained an interim order suppressing that there is a matrimonial.
No, my lord, this
And
today will not argue on
authorities have
merit.
been-
We'll dispute it.
Authorities have been restrained from releasing that money which the learned trial court has granted.
But it has to come for final disposal. My lord, I have no objection. Except any other day, subject to.
There was some draft agreement for amicable settlement. What happened to that?
They did
Earlier,
not
this matter
agree.
was hard, Lordship, and therefore, after amicable settlements, both the parties have gone for amicable settlement.
Then what happened?
I gave a settlement that and that I'll pay 50% of my whatever I get from this.
No, we
because
don't know. We don't want to know
It
the
failed.
details.
Yeah.
What is the
They did not
status?
agree.
They did not agree.
The both of us did not agree.
No, I did not agree. No, it's my proposal. You did not agree.
No, our proposal you did not agree.
Whatever way it, my lord, we will not argue.
Only the judicial orders of the trial court has been sorted. And there is seeking clarification.
All right, let it be on 7th December.
Seven.
7th.
Yes, no problem.
At the request of Mr. P.D. Kaur, Learned Senior Counsel, matter stands adjourned to 7th of December. Mr.
Yes.
K. Kolita appears for Royal India, Mr. J. Patwari for the private respondent. Yes.
May I please, your lordship?
Yes.
Can it be passed off for time being, lordship?
Why?
Lordship, my senior is on legs, lordship, in court number 7. Regarding item number 2.
Yes, Mr. Sharma.
Tuesday, can we take it on Tuesday? Because-
Huh?
Can you take it on Tuesday?
Tuesday.
Lordship. I'm still listening. I'm sorry.
Yes, sir.
My apologies.
Yes, please. Sir,
Okay. Yes. That question paper.
We'll ask to bring the reports.
It is about that question paper.
Lordship, just Lordship wanted to have this have a look on the records. The records are with me. So basically, Lordship, that issue was, I mean, whether there was some kind of foul play.
Anyone for the private respondent?
The one more, I think, Mr. Barpuzari was appearing.
All right.
No, he also appeared. Rajiv Barpuzari also appeared in the last.
They are for the private respondents whose appointments are being challenged.
Lordship.
So your only ground is that you are questioning the selection or manner of selection by raising a doubt that it was,
In fact,
question was received by the father.
question was by father. And let's see. Firstly, very surprised that we have applied them under RTA. Firstly, we have participated in the proceeding. Innocently, we know that process is going on smoothly, so we participated. Subsequently, we came to know about all the things, about all the anomalies which are being communicated. So we have applied an RTA. Firstly, what RTA was there as to one RTA was there as to whether there was any selection committee. So they said yes, there is selection committee, comprising of 4% to look into overall selection process. Overall selection process. Well, it is very surprising. Overall selection process, the F1 selection procedure was constituted. But very surprisingly, that selection committee had not been allowed to do anything. Not a single meeting of the selection committee was taken. Only at last final selection of the candidates, the meeting was taken. Otherwise, nothing was done by that committee. But in fact, that was overall selection committee. That my look, you can see page number 21. Page 21 of the reply of page 21 of our affidavit reply. Page 21 of our affidavit reply. In process to government letter number 36 dated 26/10/14 and for appointment of two vacant posts of judges in the office of undersigned, a selection committee are constituted for the following members. The committee, after completing the entire process of appointment, entire process the committee was constituted.
Wait, you are referring to page number
Page
21.
number 21 of my affidavit reply.
Yes.
Reply to whom? You didn't copy of it.
This is an order. 20th March.
It is 20th March.
20th March order. What do you want to say?
In this case, they have actually constituted a selection committee comprising of 4 persons, and this select committee, last line, the committee after completion of entire process of appointment, as per set rules of the government of Assam, will recommend suitable candidates for appointment in due time. So it was an overall committee for looking at the overall process of appointment. So this committee, in fact, this committee
No,
was
page number 20 is communication between PIO, DIC and State Information Officer.
yes.
So
Actually, they were not supplying us details only after intervention of State Information Officer.
in appeal,
Hmm.
they have supplied us this information. This information was not being supplied by them.
So
So now, allegedly one selection committee was formed.
where is that order of selection committee, constitution of selection committee?
No, they have, that is the order, 21st, that is page number 21, that is the order.
Page number 20 is a communication dated 18th
The page
February
21,
21.
page 20,
Okay. Page 21.
page 21.
General Manager, District Employment.
Hmm.
Yes.
District
Then
employment officer, function officer, head assistant, public senior assistant.
yes.
So committee was to complete the entire process of appointment as per rules set by government person and will recommend suitable request. So it was committee appeared for looking into entire process. But later on we found that nothing has been done by the committee. And it is admitted fact.
Where are the minutes of the selection?
Ma'am.
Selection committee minutes.
Selection committee, that is why I am saying, Your Honor, what is happening, Your Honor? My lord, what is it, my lord? In is the 190.
Mr. Kolita, where are the minutes?
Minutes are there on the record, Lordship. Otherwise,
Then, my lord, very surprisingly, page 19, my lord.
Hmm.
It is also reply under RTI, page 19.
Hmm.
Page 19 of the same. It is reply. In reply 1, copies of departmental guidelines are not found in office records for publishing. There is no guidelines as to how the appointment has done. They are not even having guidelines. So how they
All right.
claim to have
Election pertains to which year? 2015.
15,
So your prayer today is to set aside the selection.
my lord.
And
My lord, now that when by lapse of time, illegally done cannot be legalized by lapse of time.
no, that's all right. But then what
Then next
effective
is what
orders do you want from the court?
My lord, to set aside the appointment.
And then?
To set aside. My lord, second, second, my lord, can listen second.
Hmm.
Constitution of all committee selection committee was not formed and notified. Various committees subcommittees are formed for selection process. Here, my lord, on one place, it is clear that there was a selection committee.
Lordship, there
Page
was
21.
selection committee. All the selection has been done as per the selection committee recommendation. These are all available on the records.
My lord, that is why I am showing, my lord.
Now I don't
One
know, like, I mean,
selection
what-
committee is
what
there,
does
page
he want?
21. Now, their officer, they are informing that constitution of overall selection committee was not formed and notified. Various committees and subcommittees were formed for selection process. That is on the court. So that selection committee was there, but that selection committee has done nothing. And now they said selection committee was not there. Overall selection committee was not there. But here it is a notification of selection committee. Then, my lord, again, they are giving contradictory replies. They are contradicting themselves because actually there was nothing. Nothing was there. All records are prepared separately. Nothing was there earlier. So, my lord, I have shown your lordship that selection committee, they have shown to have formed selection committee, page 21, page 19, they said that there was no overall selection committee. Then again, my lord, in page 50 of my writ petition, page 50 of my writ petition, that is another reply.
50.
50.
Hmm.
It says that no meeting was held among members of selection committee for adopting appointment procedure. Before the written test, computer typing test, viva was a discussion was held only on the day of original interview. So no meeting of selection committee was held to finalize the modalities of appointment procedure, about the written test, about viva. Nothing has been done. Only The overall committee meeting was held only on the date of final interview. So, in fact, the selection committee was formed, but that selection committee has been ignored. That selection committee has been ignored, and the manager, he himself proceeded with doing everything at his own. He proceeded for doing everything as his own, and they are showing various subcommittees, etc. They are showing, but actually those subcommittees are not there, my lord, because I have shown your lordship that one of the members of subcommittee has clearly said, I was never member of the committee. He clearly, Mr. S. Gam says that I have been never a member of any committee, but surprisingly, he has been shown a member of committee. In fact, there was no committee when we started to write applications on RTI. They were not giving us any RTI reply.
In view of the lapse of the time, what effective orders do you want?
My lord,
Setting aside, okay, we set aside. Matter will not end there.
no, let it be set aside and let there be press appointment procedure.
Will you be eligible for participation now?
My lord, definitely, my lord may give me some opportunity to participate.
No.
I mean,
What is the minimum? Is there any age limit? Age criteria?
So they have participated,
Is there any age criteria?
age criteria was not there in the advertisement.
Where is the advertisement? Where is the advertisement?
Just starting. It is at page number 2. It is original. Page number 2 is the original advertisement.
No, Lordship, I'm sorry, Lordship, it was there. Lordship, it was there. 18 to 38 years.
Where is that? Page number?
Page 21, your Lordship will find. The vernacular. And
21.
page 20, the type copy. My apologies, Lordship, it was there.
35 years.
18 to 38 years.
38 years.
38.
So you are beyond that age today.
I have, my age is just clarified. I am beyond that age now. But in view of this matter that I am contesting the case, I have filed the case. If the matter is sub judice, so definitely the High Court may, in exceptional case, the High Court may allow me to participate in the process.
We can allow you to participate. We may even issue a direction for them to consider condonation of your age. All this is all right. But you see, there is a responsibility on the council also. This is a matter of 2015. The order sheet does not reveal anything as to why the delay for 8 years has occurred. Nothing.
I heard the matter is pending before the...
No, you can't just take an excuse to say that the matter was pending. Notice was issued on 21/12/2015. Next day, the direction was to list it on 9/3/2016. Matter gets listed on 26/4/2018. 3 years. No application, no mentioning, nothing, no complaint before the registry why the matter was not listed. Then it gets listed on 2021. So there is some responsibility of the council.
Since 20, it was COVID.
No. Since 20, maybe from 15 to 19, it was not listed.
That is what.
Then, so see, if you want an effective relief, you must come to the court. That is the reason why you have come to the court. You could have very well gone and filed a civil suit. Why come to the court? Invoking extraordinary jurisdiction. Because of urgent orders.
There, my lord, is correct, but one thing is that if I would have come belatedly,
maybe
if I come to the court belatedly, that is different matter. If I come to the court belatedly,
your explanation that you have come at the immediate opportune time, but the matter was not listed. Matter doesn't end there. What steps have you taken to ensure that the matter was taken up? Can you show us any mention? Can you show us any application you have filed before the registry that why this matter was not listed in spite of a specific direction by the court? Nothing. No steps. Today, you turn around and you put the burden on the system to say that we had come at the right time. It was the duty of the court to list it.
That is my lord, that is one
yes, we accept. we
That
accept,
is, yeah, my lord, that is one.
we
aspect of
accept a greater responsibility that yes, there is a delay caused because of the matter being not being listed. But what steps as a council have you taken?
That is also, that is
Yeah.
your lordship.
When the
right, that is-
advertisement says
There our lordship is special.
you file this case
Hmm.
showing your age to be 34 years.
So, that was actual age.
No, all right, 34 years. So you had 4 years time to participate,
My lord,
assuming we interfere with the selection.
my lord.
Today you are overaged. So what effective orders do you want from the court?
Actually, my lord, called on the part of both, on the part of the council as well as the registry. Court lies on both sides.
But
Because for that,
accepting the
for
fault
that-
now,
Hmm.
accepting the fault now
Hmm.
cannot
Now, for that.
turn the clock back.
No, for that, my lord, for that, my lord.
For that,
Basically-
the petitioner should not suffer. I am with you. Now you tell me
Hmm.
what effective orders do you want when the petitioner is on date
Hmm.
is not eligible to participate?
My lord, firstly, my lord, the one thing is that one appointment has been one good, entire proceedings of appointment is being illegal.
I accept.
Wrongly considered.
I
In
accept.
that case,
I accept all your arguments.
In that case, my lord,
What
will the court allow
illegality?
that illegality to continue?
This is not a. This is not a PIL.
Because no,
This is not a PIL.
no.
This is a writ petition filed by a person aggrieved that his selection or our selection has not been made as per rules.
That is correct.
Assuming we accept your submissions, we issue a writ, set aside, you are not entitled to participate because you're overreached.
Because of whatever may be, there is some mistake on the part of the registry, some mistake on the part of the lawyer.
No.
That is one thing. But for that,
Unless you give a satisfactory answer, we are not inclined. I'm being very candid with you. You must come up with a satisfactory explanation. You give us show us an authority to say that no, under such
Let
circumstances.
it be on Tuesday, my lord. I can satisfy you.
Otherwise, as on date, you may have a good case. You may have made out a good case. But no effective orders can be passed today. What orders?
One thing is that can they be allowed to enjoy the fruits of wrong committed by them?
May not be,
My
but
lord,
this
lapse
is
of
not a
time,
PIL.
lapse of time cannot give them right to enjoy the fruits of fraud committed by them. That is decision of this honorable court. Also, I shall bring before the honorship.
You bring it.
Yes,
You bring.
I shall be before them. That they will be allowed to enjoy the fruits of their fault wrong committed by them. But
You allowed them. From 2015 to 23, you permitted them.
They are enjoying. They are
No.
they are enjoying.
They are enjoying
they
because
should be satisfied
they
that
are
they have enjoyed the fruits.
Mr. Council, they are enjoying because you have been lax. You have not been vigilant. You did not. You did not take your steps necessary to get this matter heard within the period required.
It will on Tuesday, my lord.
Not Tuesday, then it will get deferred to December 5th. 5th December.
I shall not be able, my lord. But December 5th not be able. I shall be in December. I can
After 11 December.
something now 2021 December.
November
20th November.
28.
28.
Mr. Kolita,
Lordship, wait.
let the matter be listed again on 28 November, enabling Mr. Sharma to address the court and place the relevant judgments that he desires.
Obliged.
It's fixed for orders today.
Did we fix it for 2 o'clock or no?
I leave it to your lordship.
Yes. No, we'll take it up. I just vaguely remember that did we mention that we'll be taking it up at 2? No.
No. Perhaps I do not know. Maybe I missed it.
Where is that uh, rules that you submitted that sub staff does not include sweepers?
Your lordship will find at page number 79 of the additional affidavit that was filed on 21/9/2023. 79 3.4 recruitment in sub-staff category for the post of security guard in subordinate staff cadre, and then at page 80 for other posts under sub-staff cadre. That is housekeeper cum peon. 4.4.2. And at page 81,
Sorry. Page 80.
yes, page
House-
79, it spells out recruitment in sub-staff cadre. Now, in sub-staff, 4.4.1 is post of security guard, which we are not concerned with here. Then at 4.4.2, that is at page 18, it is housekeeper cum peon. And the job profile of housekeeper cum peon, your lordship will find at page 81. C.
Yes.
And educational qualification is 10. 10 pass. And mode of selection, online test. But till today, there is no process by which the sweepers will be selected. However, that 2007 guidelines which says the sweepers full-time, part-time will be selected.
There was one communication saying that it does not, these interviews, excluding interviews of the
Yes,
sweepers.
that
Where
is,
is that?
your lordship will find in their affidavit. Page number 45. That is the minutes of a board meeting held on 4/5/2016, page 45 of their affidavit.
45.
45. It was resolved that approval is accorded for amending the selection criteria by discontinuing the interview process for recruitment in clerical grade and subordinate cadre, excluding sweeper.
May I please, your lord? In this same page number 45, the last paragraph, also resolved in the second paragraph. That till receipt of the clarification permission from the DFS, the process of recruitment of the sweeper may be kept in a bin.
The purpose of
That is why it has
highlighting
been
that part,
excluded.
that it excludes sweepers, because the sweepers, they do not have any other process. They have till date, they have not come up with any process of selection.
How have you, what steps or what procedure have you adopted for clerical and sub staff today at present?
This is online test and other, this as mentioned in page number 89, your lord. Of the additional affidavit.
Page 81.
81.
Yes. Selection process shall be based on simple bilingual online test in local vernacular language English for evaluating the literacy level of the candidate.
So earlier it was only interview.
Earlier it was only interview.
Then
For
you,
all.
for all.
It's
Then you had adopted a policy for having this
yes, for clerk and sub-staff.
sub staff,
But
nothing for sweepers.
Nothing for sweepers. Yes.
and
In
that,
fact, sweepers, you have not even taken a decision on the ground that clarification has not been received.
Yes, your lord.
But you are engaging sweepers?
Yes, your lordship, to some extent it has been true.
On what? Daily wage?
Yes, your lord.
on contract.
Is there any resolution for engaging the sweepers on contract?
That I have not gone through, your lordship.
Okay. Take down. Heard learned counsels for the parties. This writ petition is filed by the petitioners seeking a direction from this court, seeking a writ of mandamus and or appropriate writ direction or order to publish the select list in connection with the selection process for appointment of sweepers in the under various branches of the respondent bank, which is
At that time,
Allahabad Bank, within bracket, now
Indian Bank.
merged with, later
Indian
merged with Indian Bank.
Indian.
Bracket closed. Stop. Para. The petitioners were engaged. You were earlier on part-time appointment? No.
Not all, some. They participated in the recruitment process.
No. Were you at the time of participating? Were you
Not all,
not?
some. Not all.
You were already working.
Yes, some of them were working.
Some of the petitioners and some of them were engaged as part-time sweepers or on casual basis in the various branches of the erstwhile Allahabad Bank. So, an advertisement dated 30/11/2014 was issued by the then Allahabad Bank inviting applications for various posts
Of full-time sweeper, part-time sweeper.
this is only for sweepers.
Yes. Yes, sir.
Inviting an application for full-time sweeper, part-time sweeper.
On half and 3/4 of
On
scale.
half and 3/4 scale of wages.
Yes.
Stop. The mode of selection reflected in the advertisement was within quotes through interview. The process of selection was the various criteria for age, etc., was also reflected. Stop. The reservation for the posts branch-wise was also reflected. Stop. The petitioners being eligible for being appointed in terms of the said advertisement applied for the interview, applied for the said posts, and their interviews were conducted centrally or on branch-wise?
Branch-wise, sir. Branch-wise.
So they applied in branches.
Yes.
They applied in the respective branches and the interviews were conducted.
And the page 58 of the additional affidavit, I have given the dates on which interviews were held in all the branches.
The various dates on these interviews were conducted on various dates, which is not disputed by the respective by the respondents. Stop. The petitioners having appeared for the interview were awaiting the results to be declared and were expecting that their appointments in terms of the advertisement issued will be made by the bank. Stop. However, no such results were declared. The petitioners approached the various authorities in the respective branches, and subsequently they were informed that there is a
No, my lord. That information was not given. It is only when we filed the writ petition, they have come up with this stand in the act.
however, no information was forthcoming. Stop. Being aggrieved, they approached this court by filing the present writ petition. Stop. The writ petition was initially heard and disposed of by the coordinate bench of this court, dismissing the said writ petition by order dated
3/6/2022.
3/6/2022. Stop. Subsequently, a review petition was filed by the petitioners, being review petition 158 of 2022. Stop. The review petition was allowed by order dated 10/4/2023, and the earlier order dated 3/6/2022 was recalled. Stop. Thereafter, the matter has been listed for hearing and was heard on several dates. And from the pleadings exchange, it is seen that there was a decision taken in the at the appropriate level in the authorities of the bank that the interviews conducted for the sweepers will be discontinued in view of an advisory received from the Ministry of Finance, Government of India. Stop. Pursuant to this advisory, the bank had sought for clarification in respect of the interviews, in respect of the process for recruitment of the sweepers. Stop. Para. Mr. S. Chakraborty, learned counsel for the petitioner, urges that pursuant to the writ petition being filed before the court, the bank authorities, by filing respective pleadings, have placed before the court a resolution adopted by the then Allahabad Bank that the process for selection, the selection process has been discontinued. Sorry, the selection process has been discontinued as in terms of the advisory received from the Government of India. That selection by way of interviews for recruitment process of PSB means, what is PSB? Public service, public sector, public sector banks for the post of sub-staff and clerk should be discontinued. Stop. Learned counsel for the petitioner submits that once the selection process have been initiated by way of an advertisement, after the petitioners had appeared for the interview and the selection process, the same could not have been abandoned merely on the basis of an advisory without subsequently taking a decision as to the fate of the selection in which the petitioners had participated. Stop. The further submission of the learned counsel to the petitioner is that the advisory, even if taken on advisory on the face of it, reveals that the discontinuation of interviews for recruitment process pertains to clerical and sub-staff posts in public sector banks. Stop. Sweepers are not included in the sub-staff or are not considered to be sub-staff or clerical posts. Stop. And accordingly, there is no basis for the bank to abandon the selection process initiated by not proceeding and concluding the selection process by declaring the results. Stop. Learned counsel for the petitioner, referring to the rules, regulations. Is it regulation? What is this?
The recruitment policy.
Recruitment policy of the bank refers to the referring to the recruitment policy submits that in that for recruitment of staff cadre, the various criteria are issued, and the vacancies under staff cadre are vacancies for the post of housekeeper cum peon. Stop. There are separate regulations prescribed for filling up of posts of security officers and drivers. Drivers also, I think.
Your Lordship, page number 81, that is upkeep of the branch oblique office premise.
Drivers.
Anyway, security guards. Stop. However, insofar as the sweepers are concerned, there is no set of regulations framed by the Allahabad Bank or by the Indian Bank. Indian Bank. So
Earlier, when it was Allahabad Bank, there is a policy of 2007, which your Lordship will find at 62. It says that recruitment of sweepers by way of interview only.
Learned counsel for the petitioner further submits that the job profile reflected in the regulations for sub-staff cadre are clearly described. So these job profile do not match with the job profile of a sweeper. Stop. Learned counsel for the petitioner further submits that the earlier regulations of 2007, where is it?
Page 62. Start from page 62.
62.
Yeah. And your Lordship will find at page 67 mode of selection.
So 62 is
62 of the additional affidavit. Annexure 3, additional affidavit.
It is at 65. 65. And exact 3. I have corrected. I have corrected.
Annexure 3.
a part of the pleadings of the additional affidavit.
My Lord, may then have a look at page 65.
65.
Recruitment of part-time.
Yes. It submits that by an inter-office order dated 19th of May 2007, the bank already has in place the policy for and the procedure for recruitment of part-time sweepers. Stop. Under the said policy,
page 67, mode of selection.
The mode of selection reflected is by way of interview
only.
Interview. Stop. It is pursuant to this recruitment policy that the advertisement dated so and so was issued by the bank and the petitioners had participated. So it is the submission of the learned counsel for the petitioner that as on date, that earlier policy has not been modified or altered or replaced. Stop. Under such circumstances, the bank is duty bound to continue with the selection initiated in respect of the sweepers and carry it to the logical end and declare the select list of the sweepers conducted. Stop. The learned counsel, in support of his arguments, relied upon the judgment dated rendered by the apex court in NT Devenkanti, reported in 1993 SCC 157. Only one.
Paragraph 11 and 13.
Para 11 and 13. Only one judgment. All right. Para. Par contra, Mr. M. Sharma, learned counsel for the bank, disputes the submissions of the learned counsel petitioner. Stop. He submits that in view of the advisory received from the Department of Finance, there was no option but to suspend all the selection process, including the interview conducted in respect of the sweepers. Stop. The bank, having now been merged with Indian Bank, the decision is required to be taken by at the appropriate level by the Indian Bank. As on date, no such decision was forthcoming, and therefore no steps have been taken to either cancel the interview process or proceed with it any further. Stop. In support of his contentions, learned counsel for the respondent replies upon the judgment of Jitendra Kumar.
Yes, sir.
Reported in 1985 1 SCC 122, para 60. Rival submissions of the respective counsels have been carefully considered. Pleadings on record have also been perused. Judgment cited, the bar have also been noted. The only issue which is before this court is the conclusion of the process of the interview initiated by the bank in respect of employment of or engagement of part-time sweepers. Stop. A careful perusal of the pleadings revealed that the advisory, you'll have to tell us the page numbers.
Yes, sir.
The advisory issued by the finance department is in respect of discontinuation of interviews in recruitment process in public sector banks for junior level posts. Stop. The advisory clearly mentions that the interviews conducted for recruitment process should be discontinued for clerical and sub-staff posts in public sector banks by 31/12/2015. Stop. For convenience, the said advisory is extracted below page number 42. Stop. A similar advisory was Thereafter, another advisory, another communication is available, issued from the Department of Finance to all the chief executive of the Indian Banks Association, that the decision to discontinue interviews for recruitment process of public sector banks for the posts of sub-staff and clerk has been arrived at by the Cabinet Secretary / DOPT level. And therefore, the banks which are not in agreement with the decision may approach for relaxation with full justification. Stop. It is the submission of the respondents that pursuant to this advisory, the clarifications have been sought for by Indian Bank.
Other than Allahabad Bank.
Allahabad Bank, which clarifications have not been received as on date, and consequently, no decision has been taken to proceed further in the recruitment process of the part-time sweepers initiated. Stop. A careful perusal of the regulations of the bank revealed that the bank has already a recruitment policy in place, and the various posts and are elaborately reflected in the regulation. Stop. The regulations also specify the manner of recruitment as well as the eligibility criteria for the various posts. Stop. Under regulation 3.4, recruitment in sub-staff cadre. Procedure for recruitment in sub-staff cadre is prescribed. 4.4.1 pertains to the for the post of security guard in subordinate staff cadre. Stop. 4.4.1 4.4.2 is for other posts under the sub-staff cadre. Under this head, the posts specified are the housekeeper cum peon. Stop. The job profile of these posts are also prescribed, which is as under page 81, job profile. Stop. The mode of selection prescribed is within quotes simple bilingual online test in local vernacular language / English for evaluating the literacy level of the candidates to suit the requirement of a job role. Stop. There is a provision period also prescribed for clerical and subordinate staff cadre. Stop. The regulations do not reflect any prescription for recruitment of sweepers or part-time sweepers. Stop. Whereas from the pleadings, whereas in the additional affidavit filed by the petitioner, an extract of a recruitment policy in respect of part-time sweepers is enclosed. Stop. This is a communication issued by the general manager of the bank dated 19 May 2007. In terms of this recruitment policy, it appears that the bank has a bank has a policy for recruitment of, for laying down, a bank has certain guidelines or procedures laid down for recruitment of part-time sweepers, for direct recruitment of part-time sweepers. In cases such posts cannot be filled up internally by effecting changes in the cadre of existing eligible part-time sweepers. Stop. Where is the process of selection under this 19, page number 65?
67.
Under the said policy,
Mode of
the-
selection.
the mode of selection is
Second paragraph.
prescribed at clause 6 as under. Selection will be made through interview only. The candidates will be judged on the basis of their overall performance and the overall impressions of the members of the internal committee. Stop. At clause 8, preparation of select list or merit list is prescribed, and under the said clause, the category-wise select list of the qualified candidates will be prepared by the concerned zonal offices in the order of merit rank. Stop. In the affidavit in opposition filed by the bank opposing the said additional affidavit filed by the petitioner, the bank reiterates its contentions and averments made in the earlier pleadings that in view of the advisory received from the Finance Department, Government of India, the interview process has been kept in abeyance. Stop. Although clarifications have been sought for, no communication to that effect has been received by the bank authorities. Stop. And therefore, the bank had resolved to keep the recruitment process for the sweepers in abeyance. Stop. The stand of the bank in their in their affidavit in opposition opposing the additional affidavit is that the sweepers are indeed posts which are also included under the sub-staff, subordinate staff. Stop. Parent. There is no denial by the respondent bank that as on date, the services of the sweepers are being engaged, are being undertaken by the bank on a casual or a daily wage system. Stop. The policies in place of the bank have also not been denied. Although the contention of the petitioners and the position in the under the service regulation that sweepers are not included in sub-staff have been disputed. However, no specific material has been placed before the court to suggest that there is a separate recruitment policy or a separate guideline which governs the recruitment of sweepers. Stop. The bank has maintained its consistent stand that clarifications have been sought for from the appropriate authority. However, in the absence of any clarifications being received, the selection and recruitment process of the bank of the sweepers have been kept in abeyance. So, what is not denied is that notwithstanding the clarifications not being received from the competent authorities at the appropriate level as submitted by the counsel for the bank, there is no clarity under what circumstances and what policy the bank has continued to undertake the services of sweeper in various branches across the state on a part-time or a daily wage basis. There is no policy available on record and presented before the court. So, there is no denial by the bank that the services of the sweepers are essential for their day-to-day office work at the branches. Stop. Under such circumstances, the bank authorities cannot be permitted to take undue advantage of a circular issued by the finance department, which essentially concerns with the sub-staff caterer. Stop. Considering that the prayers in the writ petition are for declaration of the results of the selection process, this court is of the considered view that the bank, being a public sector bank, cannot be permitted to extract services from individuals, divorce any rules or regulations. So, if any services are extracted from any individual, there must be a proper set of regulations in place by the bank. Stop. What is noted is that the bank, on one hand, has maintained the stand that they have applied for clarification from the government, and until the clarifications are received, the process for recruitment of sweepers, as advertised earlier, has been suspended. Will be kept in abeyance. Stop. While on the other hand, they are expecting services of the sweepers, part-time sweepers, on a daily wage or casual basis, without there being any policy in place. Are some of the petitioners also working presently?
Some of the.
It is also not denied at the bar that even some of the petitioners who appeared before the interview have been allowed to work as part-time or casual sweepers without the declaration of the result or conclusion of the selection process. So, under such circumstances, the bank, being a public sector authority, cannot be permitted to extract services contrary to the provisions of law and the ideals enshrined in the Constitution of India. Stop. The bank is duty bound in law to have its set of regulations in place for selection recruitment process to be adopted by for all cadres, including the sweepers. Stop. Under such circumstances, This court is of the considered view that specific directions be issued to the bank, mandamus be issued to the bank to conclude the process undertaken by way of the advertisement dated so and so for appointment of sweepers. So the results be declared and the petitioners, if selected, necessary for appointment, the appointment orders be issued. Stop. The bank, on the other hand, is also permitted to take appropriate decision for bringing in a set of regulations for recruitment of sweepers if required. So, that's all.
My lord, the declaration within the time frame.
This declaration of the results is directed to be made
Within 4 weeks.
immediately within the outer limit of a period of 4 weeks.
Your lordship, maybe 8 weeks, your lordship. Because we have to send the proposal to head office and after taking all the permissions.
Against the order of the court, they will have to take a permission. What
I just
permission
pray
is
for
making?
8 weeks.
8 weeks is too much. 4 weeks.
6
It's already
weeks, maybe.
delayed.
Your lordship, 6 weeks.
4 weeks, 4 weeks.
Your
4
lordship,
weeks.
some leniency.
You start the process. If you require, you pray for extension of time, we'll consider.
Your lordship, once the writ petition has been decided, then your lordship, kindly make it your lordship 6 weeks.
For what purposes?
Your lordship, we have to send the proposal to head office, then again.
We don't know what you want to do. We're issuing you a mandamus. You do it.
Yes, your lordship.
As simple as that.
Only prayer.
Your only remedy is to go in appeal if you want. Disposed. All the cases. All the other cases are also similar matter. Allahabad Bank. Same recruitment process. Different branches.
Different branch.
Names. Kindly give the names of the parties. Writ petition wise. Huh?
Lordship wanted to see the minutes of the DPC as to why the case of the petitioner was not taken up for recommendation to the post of superintendent.
Where is the minutes of the DPC?
Lordship. Receive, lordship.
Dada, eto logo. Dada. All parties are available.
Lordship.
All the respondents are represented.
Lordship, respond number 5 and 6.
You are appearing?
Yes.
And
Do you have a copy of this with you?
Yes.
So, who's respondent number 4?
Lordship. 4 is the public service.
What is the name of the respondent 4?
No, it's I think 5, Lordship. Ranjit Kumar Bhattasari.
Huh?
4 is the APSC, Lordship. Assam Public
Not
Service.
four, not four. Six and
yes.
7.
6 Ajit Kutum, Lordship.
And then 5.
5 is the Ranjit Kumar Bhattacharya. Serial number, Lordship, in page 2, Lordship. Serial number.
Who is representing R5? Respondent 5? You are appearing for 5. 5 and 6.
And 7, Lordship, Allokesh Das.
Someone expired, isn't it? Any of the respondents expired or? No.
No, Lordship.
They're represented.
They are
5, 6, 7.
Yes.
All right. Now, on what ground the petitioner was not selected?
Lordship, the selection was held, Lordship. The DPC was held. DPC meeting dated 26/2/2019.
We have seen that.
Yes,
we are looking into the internal page number 2.
Yes, Lordship.
There at serial number clause D.
Yes, Lordship.
Selection of 17 vacancies.
And 13. 11, 12, and 13.
11, 12, 13. So the name of the petitioner is not here.
Yes, Lordship.
Question is why?
Lordship, these are the selected candidate, Lordship.
That is what we are asking you.
Yes.
You have selected somebody, you have not selected somebody else.
On the basis of the, it is stated in the roster point.
What are the rules?
Rules is that as per the existing service rules 9, 11, 13 of the Assam service rules 1970 as amended up to 2000, the departmental selection committee meeting for consideration of the
Wait, what are the rules called? Name of the rules?
Rules is
13, my lord.
yes.
Method of selection, rule 13, my lord. It is quoted in the writ petition.
It is there in the writ petition?
Yes.
You tell us the name of the rules?
The Assam Supply Service Rules 1970.
It is in page 6 of the writ petition. Rule 13, method of selection.
In the minute, Lordship.
Yes.
Page number 2, Lordship, internal page number 2. It is specifically stated that SCRs, it is position of SCRs.
Yes. Page number 30.
No, Lordship, page number.
No, the rules. Where are the rules?
Rules 13, page 6, my lord.
Page?
6, my lord, of the writ petition.
6, the writ petition.
Here is the, in every case, Lordship, got it, my lord. Page 6. Writ petition.
You have quoted it.
My lord, I am quoting.
You do not have the extract of the rules.
Yes, I had the set of the.
Let us see the rules. The rule to yet Yes.
In the rule 13, my lord, Lordship may find in every case a junior member in a cadre is selected in preference to his senior. In that cadre, the committee shall record in writing the reasons of such supersession. Whether the DPC has recorded the reasons for supersession.
Mr. Goswami, do you have the rules?
Rule 13.
Yes, Rule 13.
13 is the petition itself.
Rule 13.2, then read Rule
Yes,
13.2.
the selection shall be made on merit and suitability in all respect, with due regards to the seniority and to the following aspects of a candidate, namely personality and character, traits, energy, and general intelligentsia, previous record of the service. The basis is there are four along with the seniority, lordship. These are also the considerable things, lordship. It is not stated only the senior should get the promotion, lordship.
No, merit and suitability.
Yes, lordship.
Now the question is, how do you how do you decide the merit and suitability?
The committee decided, lordship.
On what basis? That is what we want to find out.
Yeah.
Our job is not to find out whether the committee is right or wrong. We have to find out whether, as per the rules, they have done their job. That's all. You show us. You show us from your records how it has been done.
The minutes itself stated, lordship, as per the rule, as per the existing rules 9, 12, and 13, the selection was made, lordship. It means on 13, the provisions of rule 13 is also considered here.
Mr. Goswami, are you able to tell us how it has been done? Besides what the selection committee has done, we are not asking you that. We are asking you as what your client, the department, and the committee, how they have arrived at this selection process. Is it reflected anywhere?
No, lordship.
Is it not available in the records?
Lordship. This is the DPC record.
No, but how the DPC says that we have decided, what have they decided? Where are the minutes again?
Yes, my notes, lordship, it is my internal page 3, lordship. Third page.
Of the affidavit?
No, lordship, not affidavit. Lordship, the instruction.
Oh, instructions. You have given the instruction.
Yes.
Yes.
Third page. Minutes of the meeting of the departmental selection committee.
Yes. Do you have the records with you?
No, lordship, the minutes is DPC minutes.
You have to get the records. You understand from the records how this election is. His limited grievances that
lordship.
You see, you please understand that.
Lordship.
We are not here to scan your records and find out what the DPC has done. That is not our job.
Lordship.
His grievance is that the DPC conducted the selection without following the process prescribed under the rules.
Lordship.
These rules are meant for all,
Lordship.
including the department.
Lordship.
The department has framed the rules.
Lordship.
So there must be a reason why the rules have not been followed. Number one. Number two, if you say it has been followed, you show us from the records how the rules have been followed. So the petitioner is admittedly senior to the private respondent.
Lordship.
Now, his name was not considered or found suitable by the selection committee.
Lordship, here in this case, lordship, private respondent 6 and 7, lordship. Regarding private respondent 6, lordship, is a roster of
petitioner is what?
planes,
Petitioner is what? Unreserved.
Unreserved.
He is SC.
SC.
Yes, but these are the two are unreserved and one is the ST planes. Respondent 5 is the unreserved candidate, 6 is the ST planes, and 7 is the unreserved candidate. Therefore,
no, but from here it appears that there is one SC candidate, serial number 4.
Yes, Lordship, serial number 4. But
Now, question is how many SC vacancies were
yes,
available?
yes, I have the list, Lordship. That. Lordship, it is Lordship, it is page number 19, Lordship, is the final gradation list of the Inspector of Food and Civil Supply. Page number 19 in the writ petition, Lordship.
Yes.
Page 20.
Page 19, following 20, Lordship. Lordship, the conflict between the petitioner and private respondents are not arise here, Lordship, because the petitioner belongs to the SC candidate, Lordship, and the private respondent 6 and 8 is the unreserved, and 7 is the ST plains, Lordship. SC here, Lordship, in serial number 4 in my notes, Lordship. Serial number 4 in my notes, Lordship, is Munindra Moral, Lordship, SC, against the Rooster Point 36 SC. And petitioner belongs to the SC. Now, Moral, the name of Mr. Moral, Lordship, it appears
at serial number 17.
Yes, Lordship. Serial number 17. It means senior to the petitioner. Therefore, there is no conflict between the private respondent and the petitioner, Lordship. Therefore, there is no grievances against the private respondent, Lordship. There should not have any grievances.
No, if this is the process how posts are to be filled up, then where is the necessity for having the suitability assessed?
No, Lordship, Lordship, there are some roster points, Lordship.
No, right. Roster points will be filled up.
Yes, Lord.
Now you have to, from your documents, you show us that there is only one SC vacancy available.
Yes. Yes, Lordship. Roster point 36, Lordship. It is in the minute D, Lordship. It is categorically stated roster point 36. It is for SC candidate, and on against that roster point 36, Lordship, one Munindra Moral was promoted, Lordship.
Let the senior friend file a PDP lordship in terms with the record, so that we can also go to the same.
What have you got to do with? How are you affected?
Because our appointment also challenged.
No, your appointment is challenged,
yes.
But you first have to show us from the records how many vacancies were available.
Lordship, in the vacancies, Lordship, total vacancies, Lordship, in the my notes, Lordship, the vacancy, year-wise vacancy position was given, Lordship. And accordingly, Lordship,
yes.
And accordingly, Lordship, in D, it means in the year of 2019, Lordship, in a part D of my notes, Lordship, it is categorically stated that 30 roster point 36 for SC and 36 against roster point 36. The serial number 4, Lordship, Munindra Moral was promoted, Lordship. He is senior to the petitioner.
There is something written here which is got
Lordship,
not clarified. This page number, the first page of the minutes.
Lordship.
If you look into the last line, I don't know in the copy which you have given.
No, but in my copy also it is like
then,
that. Scan copy, Lordship. Lordship, one thing, Lordship, I will file an affidavit, details affidavit.
No, affidavit. You are unable to give us the instructions of what affidavit will you file? There is some reflection of the position.
No.
You become eligible for which year, Mr.
2019. 2019.
2019.
SC only one post, Lordship.
So apparently there appears to be only one vacancy for SC.
Yes, and the promotion was given to the seniority basis, Lordship. He is senior.
In
More senior than the
2017,
petitioner.
there was one post for SC.
Yes,
that has been filled up for 2017.
Yes.
As per the minutes. Have you seen the minutes?
No, my lord, I have not given.
I will give you.
You go through the minutes. 2017, there is one vacancy for SC. 2019, there is one vacancy for SC, as per the minutes.
Yes.
So if you are eligible to be considered for 19, then it will be
for
against the
SC.
reserve vacancy unless and so far as 6 and 7, you are STP. Who is for 7?
I'm 7th, Lordship, January.
You are appearing. And who's for 5? You are for 5. But if he is found to be suitable, he may fall into the creamy layer.
Lordship, unreserved.
Yes, in which case respondent 5 will go.
No, it is unreserved category, Lordship.
Oh, that is what is required to be assessed by the committee,
Lordship.
which is why the markings are necessary. What is the criteria again?
Criteria, Lordship, it is described in Rule 13, Lordship.
Merit and suitability in all respect with due regard to personality and character, tact, energy and general intelligence, integrity, previous record of the service.
Merit and suitability.
Merit and suitability.
With due regard to seniority. So there has to be merit and suitability assessed. Where is that assessment? There has to be an assessment.
2017 of a regular petition from one of the 2017 of
You get the records, Mr. Goswami. You have to, you can't give us piecemeal records like this. You get your records, you understand and apprise the court how the merit and suitability has been assessed. You call for your
Lordship, in the writ petition, Lordship, page number 8, Lordship, the prayer person C, Lordship. It is
That is withdrawn.
No,
She was withdrawn by a separate writ petition with leave of the court.
No, this is the writ measure.
This has got nothing to do with this. He is now with the limited prayer for prayer B to the extent that he claims seniority over respondent 5, 6 and 7. That is your prayer, Mr. Bachchaji?
My lord, I am happy if prayer is 1 is allowed.
1.
A and B is my prayer now. C is already allowed by this honorable court.
You are now already a superintendent? No.
I am already superintendent.
So prayer A is allowed?
No, my lord. Prayer
With
is
effect from?
with effect.
Okay. With effect from.
Only effect is necessary.
No, only effect cannot be given unless you are found to be suitable.
Yes.
Yes, that has to be recorded by the DPC if I am not suitable.
No, no. In case of SC, Lordship, in case of SC, the promotion was given to one of the senior person than the petitioner, Lordship. Therefore, this was not necessary to categorically.
You kindly go through the relevant judgments pertaining to reservation. Then you address the court. It is not as simple as you put it. Mr. Goswami, we are compelled to defer the matter because the records are not here.
I would mind.
You get the records by 30 November.
30.
Is it all right for you, Mr. Bhattacharya?
Along with I have the liberty.
Or 5th of December. 5th is all right for you? 5th of December.
38 is okay.
30th, there are about.
If some holiday is there, it is the red mark, my lord.
No holiday. That's restricted.
Or 23. The 23 to 24. I get 24.
December.
Let us have it on 5th December.
5th, Lords.
5th December, Sikh Puri Roi, some.
No, that is restricted.
Restricted.
Yes. Nothing to do with the court holidays. List on 5th December, by which the respondent counsel will produce the relevant records showing the assessment made by the DPC for promotion of the petitioner vis-a-vis the private respondents 5, 6, and 7 to the post of Superintendent of Food and Civil Supplies Department.
Liberty to file an affidavit, Lordship.
You get the records. If required, we'll give you liberty then. Yes. Names of respective counsels be recorded for respondents 5, 6, and 7. Yes. Yes.
Pleases you, Lordship.
Lordship, before starting, Lordship, may I plead, Lordship? Lordship, in this case, Lordship, some instructions are required, Lordship, regarding as the matter is very much technical and the date of counting, Lordship, that I cannot account from my own side, Lordship. I asked the person who contact with us, Lordship, but he is on leave, Lordship. He is coming in the last week of this month, Lordship.
All right. Yes. What was your prayer?
Your Lordship, on the relegation part, Your Lordship, I made time period calculation, Your Lordship. I would like to give Your Lordship.
But he won some time.
First week of December, Lordship, I will be able to.
5th December, all right. We'll have it on 5th December.
Lordship. 6th, Lordship, 6th.
6th December. All right, 6th of December.
No more further adjournment may be.
Lordship, this is the first time, Lordship, I am taking interment. Not always I am taking interment.
Matter deferred to be listed on 6th of December as
Deeply
the prayer of the learned CGC. MSP does for petitioners. Yes.
Deeply obliged.
May I please, your Lordship? On this, Lordship, in this matter, I have received the instruction. I like to place in the affidavit, my Lord. Yes.
Mr. S. Dr. Leonard, Standing Counsel PNRD, prays for and is granted 3 weeks' time to complete his instructions and file affidavit if so advised. Mr. D.A. Kayum, Learned Counsel for the petition, does not object. List after 3 weeks.
I never.
May I please, Lordship? Lordship, I'm appearing on behalf of Mr. P. Nayak. He is, my lord, on Lex in court number 2. Lordship, he has instructed me, Lordship, what has happened is on the last occasion, your Lordship has directed us to get the records. The records will be receiving it, Lordship, most probably tomorrow. Therefore, my lord, I pray that, my lord, it be, this matter be fixed in the next week so that we can produce the records and Lordship can go through it.
What was the issue here?
It's a promotion matter, my lord.
Promotion from?
Actually, my lord, in this case, the petition is still the arbitrary and unfair action from the part of the
Mr.
respondent.
A. Fukan, Learned Counsel, submits that the records called for will be received tomorrow. Please for time to place the records before the court. Prayer made is not objected to by the counsel for the petitioner list in the first week of December.
My lord. Deeply blessed. First speaker, please.
This matter we have sought for instruction from the client's lordship. That is yet to be received, lordship. So I have prayed for accommodation for today, lordship.
If you have not received, it's better to be dismissed. No.
Lordship, we have sought for some instructions, lordship, whether they want to.
Mr. MP Sharma, Learned Counsel for the petitioner, prays for further 2 weeks' time to complete his instructions from the petitioner. Prayer is made is allowed, list after 2 weeks. Mr. So-and-so appears for the respondent.
This matter relates to promotion from the post of UDA to superintendent. I have already retired from service on 31/10/2016.
Yes, yes.
The fact is that, my lord, I was initially appointed as LDA under the establishment of Director of Medical Education. Then I was promoted to the post of UDA in the year 2024. And my next promotion was due in the year 2015. And accordingly, the DPC, page 20.
Readings complete.
My lord, I was asked to obtain the record. ACR of the petition. I have obtained it, my lord.
My simple case.
Simple.
What is your prayer here?
My lord, prayer, my lord. Before that, I will place the fact, my lord. Only to revisit the order passed by the Departmental Promotion Committee, page 28, the impeaching order.
Page?
Page 28 is the impeaching order.
28.
Yeah.
Interim order.
No, my lord.
Impugned order.
Impugned order, okay.
Prior to that, my lord, I will place the fact, my lord.
No, there was an earlier a writ petition filed.
Yes, ma'am.
You come to page 25?
Yes. Part 21, first writ petition, page 21.
21, okay.
Since my promotion was not under process and some clarification was required, therefore this honorable court directed the authorities to finalize my promotion, expedite my promotion, and accordingly, page 23, as per honorable court's order, considering the 3 years ACR, I was promoted.
Recommended.
Recommended, yes. Clause 2 in the that APC meeting, my notes, all the ACR for the year 2013 to 16 are found to be fair and good. And accordingly, therefore, Giram Hazarika petitioner is recommended for promotion to the rank of superintendent in the office of the Director of Health Service. In spite of that order, my lord, that order was passed on 22nd September 2016. I was to retire on 31st October 2016. But
So no promotion was given?
Yes, my lord. Then
and you retired?
In the meantime, retired. Then I again approached this honorable court for implementation of that page 23, that promotion recommendation.
When you approached this court, you had already retired?
Yes, my lord.
Okay.
Then page 24, for the standing counsel, my senior pen was appearing. Stated
Page
that
26.
page 26, paragraph 5, 6, 7, 8. They have stated that the DPC committee, DPC has recommended my name on the basis of 3 ACRs.
Instead of 5?
Yes. The second ground taken was that my ACRs were, there were some adverse remarks. Then I raised objection stating that though there were some adverse remarks, the same adverse remarks were not communicated to me. Therefore, this honorable court based from page 27, paragraph 12, 13, 14, stated that the uncommunicated adverse remark ACR should not be taken into consideration for my promotion, and the process should be undertaken within a period of 3 months. That order was passed on 28 to 2019. After that, my lord, on page 28, the DPC in its meeting held on 4/11/2022 passed the impeaching order. Totally contradictory view, my lord, in terms of earlier recommendation. From paragraph 3, whereas it was noticed that 5 numbers of ACRs pertaining to the year 8 to 9, 9 to 10, 10 to 11, 11 to 12, 12 to 13 were having serious and adverse remarks against the incumbent Sri Program Hazarika. The next paragraph, whereas after examining all the adverse ACRs, the committee found that all were written in the same day, that is on 2, and they were not communicated to the employee concerned. Whereas they should have been communicated each year. Hence, in view of Honorable High Court's order, because Honorable High Court has already held that the adverse ACR should not be taken into account pertaining to the year so and so, and were not communicated as such, the ACRs are treated to be no ACR for the year 8 to 9, 9 to 13. Whereas other 2 ACRs before Bhogiram Hazarika retirement on 1/4/13.
So effectively, there was only one ACR.
Yes, ma'am.
Only
one.
Now, whether on one ACR, your name would have been recommended.
But I am not responsible for not completing the ACR. I am not responsible for not communicating the adverse remarks. And on that reason, I should not be deprived from my.
No, but you should have been vigilant that your ACR has not been completed.
For that, I am not responsible. They have also not communicated to any adverse remark to me.
Yes. Now what?
Therefore, I pray for revisiting the order, my lord. On the basis of one available ACR, my case will be considered. Because I have already recommended for promotion.
Now, in so far as the other ACRs are concerned,
Yes,
which were not communicated, we never communicated.
never
You did not know.
Did not.
No appeal filed.
No appeal filed.
So this should
do
have
not
been
know.
communicated.
Yes.
Why was it not communicated subsequently? So that he gets an opportunity to file an appeal.
Yes, my lord. And this honorable court in the earlier round of litigation has observed that the adverse remarks, where there was adverse remarks in the ACRs, that should not be treated as ACR. No ACR. That should be treated as no ACR.
Correct. Subject to communication. It has to be communicated.
Yes,
Then,
my lord. In terms of debt, my lord, yes, my lord, it has to be communicated.
Then?
But my lord, and more importantly, my lord, ACRs of 5 years were made on the same day, on 9/9/2013. From the year 2008 to 2013.
no, how is he responsible?
Yes.
Yes,
I'm
my
not
lord, I understand, my lord.
How is he responsible whether they were made on the same day, half day?
Yes, my lord.
You take action against your officers. Now, what are you supposed to do?
My lord, what will I submit, my lord? Because I have obtained the ACRs as well as the minutes of the last review DPC, my lord, wherein it has been reflected that only ACR of 1 year is only complete, my lord. And the rest of the 2 years, that is not completed. My lord, there is no signature of the reporting authority. Only accepting authority signature is there, my lord. And review DPC meeting held on 4/11/2022, my lord. They have held that, my lord, only one ACR in respect of only 1 year is complete, my lord.
The direction was to take into consideration the ACRs for the 5 years as per rules.
Yes.
Yeah. These are minutes and ACRs.
Yes, my lord.
Yes, my lord. And review DPC meeting held on 4/11/2022, my lord. They have held that only one ACR in respect of only 1 year is complete, my lord.
The direction was to take into consideration the ACRs for the 5 years as per rules.
Yes.
My junior have been promoted and my case also considered in the year 2015.
No appeal filed against this order.
No, my lord.
So apparently the order passed by the department is in conflict with the order of the court.
Yes.
You read from para 11 onwards.
Yes, my lord. My lord, that DPC minutes is, that is the minutes, my lord.
No, what is that page 28?
Yes, my lord.
In terms of this,
28 has been passed in terms of the minutes, my lord. That is the minutes of the DPC, my lord. Review DPC was held, my lord.
Okay.
Review DPC, that is the review DPC. 28 has been passed in pursuance of the DPC meeting recommendation.
So what is the position in the rules if there is one ACR only?
My lord, as per the order of this honorable court, last order, my lord, as page 27, para 11, in that view of the matter, this court is of the view that the present petition can be disposed of with the direction to the respondent authorities to reconvene DPC for consideration of promotion of the petitioner to the higher post of superintendent by taking into consideration of the ACRs for the 5 years as per the rules. So there was a direction to consider ACRs of 5 years. And
then you have to read para 12.
Yes, my lord. Para 12, if there be any
Para 12 and 13.
Yes, my lord. So DPC, if there be any uncommunicated remarks in the ACRs, the same cannot be acted upon by the DPC. And that has also been followed in the minutes, my lord. And the DPC will proceed to examine the case of the petitioner on the basis of only such remarks which were communicated to the petitioner, but not such adverse remarks which were not communicated to the petitioner. The DPC will examine as to whether any such adverse remarks in the ACRs had been communicated to the petitioner or not. If the same had not been communicated, the same cannot be considered by the DPC as mentioned above.
So the DPC did not conduct it as per the direction of the court.
My lord, as per the para 11, my lord.
You cannot isolate one paragraph and decide we'll do it like that. You have to read the judgment as a whole. It doesn't call for interpretation, it's a judgment.
Yes, my lord.
You have to comply it. If you're aggrieved, you have remedies available in law.
No, my lord, against this order, we are not agreed.
Then your DPC is not did not conduct it in terms of this. DPC has arrived that in view of one ACR cannot be considered. On what basis?
Because the ACRs of other 2 years, my lord, apart from the 5 years, other 2 years, those 2 years are not complete. There is no signature of the reporting authority.
So if it is not complete, then under what law you show us from the rules that what happens if the number of ACRs falls short? Huh? So you are leaving everything for the court.
Yes, my lord, because I cannot find any clue, my lord, what to do, my lord.
One of
You check up Rule 8 of the confidential role rules. You don't have. Why these are not complete? Whose signature is there? Not there. What is there in this incomplete one?
Signature of the reporting officer is not there, but accepting officer is there, my lord.
Then what is the finding of the accepting officer?
Very good.
Then, if once it is accepted, why are you concerned with the reporting officer? It is accepted.
Yes, my lord.
You go through, we'll take it up at 2 p.m.
My lord, next week, my lord, I will go through.
Today, my lord, because
Next week on a fixed date, my lord. Follow sign up
on Tuesday.
Next week, 28. List on 28 at the request of the counsel for the health department.
Yes, my lord.
Mr. D.P. Bora. Mr. N. Sorma appears for the petitioner. 28. You give him the record. You take back.
Yes, ma'am.
Records. Yes. Mr. Chetri.
My lord, item number 12 was there, my lord. I have taken the time, my lord. I was waiting, my lord, for that. My lord, urgency is there because of this retirement.
Have already passed some order, no?
Yes, my lord, on 23.
Huh? We have already passed the
My
order.
lord, only my
In the presence of your counsel, assisting counsel was there.
I'm not objecting to that fact.
Ah.
Since lordship has passed on. Only, my lord, the spot date 23rd.
Not possible. We would have done it.
Because no, on the date may be fixed, my lord.
We had fixed the
otherwise,
date. First week of December.
Whole purpose. They are going
7th of December.
Lordship.
7th of December.
Otherwise, my lord, whole purpose of filing this writ petition will be in process, my lord. They are going to be returned in December. This December.
31st December.
Yes.
We'll have it on 7th December.
Can it be some advance, my lord? Otherwise, since long, my lord, they are taking advantage of.
No, I cannot pass an order in the absence of the other counsel. You call it.
I-
No, you call the other counsel. We'll fix a date. Whoever is for the respondents, you call it. We'll fix a date.
Yes. Yes.
Fix a date. Yes.
May I please, your lordship?
Yes.
Your lordship, the petitioners, being the similarly situated persons, are seeking the benefit of order dated 26/2022 of judgment passed in WPC number 7215.
Page number.
That is 142, your lordship. The operative part is 145, your lordship.
Lordship, here in this case, Lordship, the instruction sought for they not received, Lordship.
What is the direction of the court?
Your lordship, the similarly situated persons.
What is the direction of the court?
Your lordship, the direction was that, your lordship, the person should be given the benefit of retirement retrospectively also.
Where is that? Paragraph number?
That is 153, your lordship. Paragraph number 19, your lordship.
Is it covered, Mr. Goswami?
Lordship, on that count, Lordship, I have to take the instruction from the department, Lordship. Therefore,
You read the judgment and tell us whether it is covered or not.
in last occasion, Lordship, the instruction is sought for by the Honorable Court, Lordship.
Otherwise, we are covered, your lordship.
Last occasion, Lordship, it was given, Lordship.
What is the status of the petitioners? What are they doing?
They are doing, your lordship, supervisor.
Where have you stated? Which paragraph?
Page 14, your lordship. Page 14, 44, your lordship. Paragraph number 14.
Where are your appointment orders?
That is page 130, your lordship. 131 is the joining report, your lordship.
You're appointed on contractual basis.
Your lordship. Subsequently, we all were appointed as per the order dated 26/2020, your lordship.
Where is that order?
That is 145, your lordship. While pending, during the pendency of that writ petition, your lordship, the government has passed an order, that is 155, your lordship. And in terms of that order, your lordship, the judgment was positive.
You were employed initially as Anganwadi worker.
Yes, your lordship.
On contractual basis.
Yes, your lordship.
Then were you regularized?
Yes, your lordship.
By which order?
Your lordship, on the basis of one notification, your lordship, the notification dated 4/6/2012, your lordship.
Page number?
Page number 61, your lordship.
61.
The notification was passed by the department, your lordship. Thereafter, your lordship, written test was conducted, your lordship.
Then?
Thereafter, your lordship, final merit list was published. That is page 120, your lordship.
Where are your roll numbers? You come prepared, Mr. Counsel. Placed after a week. You come prepared, you don't know what you are submitting. You are unable to point out the relevant people. Yes, where is the respondent counsel? Item 12, he wants a fixed date on
23rd.
23rd is not possible
Because
we had given you a date on 7th December.
no, since my lord, the persons are going to be retired, my lord. Otherwise, my lord, whole thing will in progress, my lord. That is why I'm praying, my lord. Otherwise, I would not have been pressed before lordship.
30th November. That's the earliest we can give you. 30th. 30th November. You're retiring on 31st January, 31st December.
Yes, my lord, I do not know, but December is the day, month, my lord. 31st, maybe.
Doesn't
This
matter.
one,
If your
two-
claims are there, even if you're retired, we can give you
But,
notional benefits.
That part, my lord, sometimes they do not think about all these persons once retired. Lordship, this petitioner 1, 2, 3, all are 58, 58, 58 years at the time of filing the writ petition.
All right, let us have it on 28th. 28th. 28th November.
Lordship. I'm extremely sorry.
Why should you be sorry?
In the
Somebody was there for you.
Please, my lord. My lord, the Canadian council is on legs, my lord. Perhaps let me pass over for the time being.
Or let me, can we give him?
Pass over for time being.
All right, timing.
Timing. I'm obliged.
Timing.
Well, there's a order from Lozima Court, my lord, Lozima, my lord, 10/11/2023, my lord. We have taken some dusty also, my lord, but refused, my lord. So, respondent 3, 3, 4, and 5, my lord. This regarding my lord, promotion, my lord, junior is promoted, my lord. The petitioner is deprived, my lord. I file a affidavit in this regard, dusty, my lord.
Service on whom?
3, 4, and 5, my lord. This private respondent, they are promoted, they are junior to the petitioner, my lord.
3, 4, and 5.
Yes, my lord. I file an affidavit, my lord.
As per office note dated 10/11/2023, it is reflected that the dusty service sought to be taken by the petitioner on respondents 3, 4, and 5 were refused. So, petitioner, learned counsel for the petitioner also craves leave to file an affidavit.
Already filed, my lord.
You have filed?
Yes, ma'am. It is there.
Yes, filed. Submits that an affidavit to that effect has already been filed. Stop. The respondents 3, 4, and 5 are presently serving in this office.
Yes, madam. Yes.
Accordingly, we direct the respondent number 2, namely the Director Cultural Affairs, to ensure service of notice on respondents 3, 4, and 5. Stop. The petitioner will take steps to furnish sufficient extra copies of the writ petition in the office of the respondent number 2, namely the Director Cultural Affairs, along with a copy of this order.
Well, I'll start to. Yes. I'll start to comment.
You are appearing for the
Yes, Lord.
cultural affairs.
1 and 2, Lord.
So very well, then we'll furnish copies of the sufficient copies of the writ petition to the learned government advocate MS M. Bhattacharjee Stop. A copy of this order be also marked to the office of the learned senior government advocate and M.S.M. Bhattacharya, additional senior government advocate, for taking onward steps in terms of the directions of this court. Stop. The respondent number 2 will thereafter file an affidavit as regards the service of notice on respondents 3, 4, and 5 as directed by this court. Let the matter be listed after 4 weeks.
And the affidavit of the respondent 2 is required, 1 and 2, madam. Affidavit of respondent 1 and 2 is also required.
The respondents, the learned government advocate is also permitted to complete her instructions and file necessary affidavit if so advised in the meantime. Matter be listed after 4 weeks.
I'll file within 2 days.
The learned counsel for the petitioner will serve the extra copies as directed to the office of the learned government advocate along with a forwarding letter within
2 days.
The course of this week.
Yes.
Lordship.
Declare.
17. Yes.
Lordship, the petitioner is against an order of suspension. The initial fact-finding report is there. We have not yet decided whether we want to initiate disciplinary proceedings against him. But
He's under suspension.
So the suspension order may perhaps go because it has not been reviewed and extended. So, but there is just one issue, Your Lordship.
Has he been paid his subsistence allowance?
That he's getting, I believe.
Yes.
Yes.
Ah.
There is just one issue, Your Lordship. In the fact-finding report, it has come to light that there is a complaint against the petitioner that in a state of drunkenness, he misbehaved with a woman. So perhaps the Sexual Violence Act might come into play. So we may be granted liberty to transfer him to a suitable other place of posting if necessary. Your Lordship.
Is there any stay? Is there any stay?
Lordship, no, there is no stay. But once, if that order goes, the suspension order, we will, of course, since we have not reviewed and extended it, that order has to go. But that liberty may kindly be granted, Your Lordship.
What
I have the report here, Your Lordship.
What liberty?
That if proceedings under the Sexual Harassment Act take place, Your Lordship, then he has to be posted at some other place.
Why should we give you a liberty? If it is entitled, if you take steps under the provision of law, you
Yes, if that observation is there, Your Lordship, that
That is their liberty, Lordship.
That
But
obs-
at that
why
relevant
that
point of
observation
time,
is necessary?
because only apprehension is that it might look, otherwise it might look very vindictive, Your Lordship, on our part.
Why? That those preliminary fact-finding reports are not before this court.
I have the reports here.
You may have, but it's not before the court.
Then I may be allowed to place it on affidavit.
No, placing it on record also we'll have to decide whether these are correct or not. The preliminary was he given an opportunity to participate?
In the fact finding, yes, his statements were also taken. Perhaps.
They recorded.
Yes, it is there.
So you take a decision. What you want to do?
Very well. That if yes, sir.
For that reason, Lordship, this honorable court observation may not be required, Lordship. But at the relevant point of time, Lordship, that is the only allegation, Lordship, lies against me, Lordship. Only the statement of others, Lordship, but no criminal case has been lodged against me, Lordship. That is the only statement of another one, Lordship. That is who is junior than me, Lordship.
Are you inviting criminal proceedings?
No.
No, then why are you
But Lordship,
unhappy that no criminal proceeding has been lodged? Third learned counsel for the parties. This writ petition is filed by the petitioner. Aggrieved by the order. Impugned order, where is it?
Lordship, impugn order dated 27/7/2020.
Page number.
Page number 20.
12.
20.
27/07/2023 passed by the respondent authorities, placing the petitioner under suspension in contemplation of department proceedings. Stop. It is the grievance of the petitioner that this order has not been reviewed. As required under the provisions of the, what rules do you follow?
This will be the What should be APDCL, Junior Officer Service Rules? I just forgot the year, Your Lordship. I'll give the year for you.
APDCL Junior Services.
Junior Officers Service Rules.
Junior Officers Service Rules.
I'll give the year.
On what ground are you challenging this order?
Lordship, already 3 months is expired, Lordship.
So you show us from the rules. Show us from the rules that it will automatically expire unless reviewed.
Yes, Lordship.
Where are the rules? Do you have the rules?
Perhaps my learned friend would be relying, I do not have the rules, but perhaps my learned friend would be relying on the Supreme Court judgment.
That is okay, but before that, what does your
The rules does not provide for that.
There's nothing about
There is
suspension.
nothing about the term of the suspension, Lord.
But does it provide for suspension?
It does provide for suspension.
So where is that?
Lord. Or should we take up the matter after 5 minutes?
In Adar Kumar Sodhari, Lordship, Supreme Court judgment.
Oh, Mr. Counsel, judgments are there. You address the court on facts.
Yes, exactly.
Why do you have to file a petition? Because Ajay Kumar Chaudhary is already there.
Yes.
Why take the trouble of coming to court and filing a petition?
Not at 2 p.m.
You can take a copy and show it to the authorities that it is a judgment, follow it.
Yes.
If you are filing a case, then you have to address on the facts and then say that this is the law which is applicable.
And at 2
Where is the rules? Is it a case of no rules or the rules being silent?
Yes, Lordship, I will press before Lordship at 2 p.m.
Lordship, what I was actually going to pray today was, since the matter has come up for the first time after notice was issued, and with the fact-finding report is already
We
there.
can close it with your recording your statement if you want.
Or if I can place it on affidavit, Your Lordship.
What affidavit?
The fact-finding report, Your Lordship.
We don't need it.
Very well.
It is not disputed. This is
Very-
the allegation here.
Yes.
He's already made
Very
given a reference here.
Very well. No, after that, it's a new report, Your Lordship. The inquiry is complete, the initial inquiry.
Very well, but there is some reference
There is a reference.
of his conduct.
It is there. It is
And this is the allegation which
It
he
is
has stated is false.
It is there.
Because of which you have placed him under
It is there.
suspension.
It is there.
So you give us the set of rules
Very well.
at 2 p.m.
Very well.
To do the position, Mari.
May please your Lordship. Lordship, this writ petition has filed for quashing the impugned order of dismissal from service, Lordship. Lordship, petitioner was working as a peon sub-staff, Lordship, in Hatipukuri, Indian Bank. During his 25 years service, he was clean and diligent, Lordship. But after that, respondent number 9 has filed a complaint before the branch manager that the petitioner has withdrawn 1,50,000 without his knowledge, Lordship, from his bank account. Respondent number 9, bank account of the respondent number 9, Lordship. He is private respondent, Lordship. But
Who is the counsel for the bank?
yes, Lordship.
Which bank is it?
Indian Bank, Lordship.
Who is the counsel? Somebody has to represent Indian Bank.
Lordship. I don't know, Lordship.
You don't know. Who is the counsel? What are you prepared?
The name of Mr. A.J. Das is appearing for respondent number 3 to 8. So he will be appearing for, I think, bank.
You call Mr. A.J. Das. Respondent to you wait for the respondent counsel.
Well, Lordship. God bless.
Yes, Mr. Goswami.
My senior used to appear for respondent number 4, 5, 6, and 7, Lordship. Now, Lordship, we have lost contact with the client, so an accommodation is sought for Lordship.
No accommodation. 2012 matter, what accommodation?
It's for 2 weeks, Lordship, so that I may be able to communicate with them.
You have lost contact, you said.
Yes, Lordship, I'll try to establish.
This is a case, Lordship, the petitioner were appointed after selection made by the APSC as a assistant engineer. They are working. Their gradation lists are published. Some junior engineer obtained BTech degree in 2003. Thereafter, Lordship, they have been recommended for promotion to the post of assistant engineer as per Assam PW service rule. Thereafter, Lordship, without approval of the APSC, they have been recommended, they have been promoted to the post, appointed as a assistant engineer. This is not promotion. These are appointed as a assistant engineer. Now they have filed a case before the Lordship Administrative Tribunal claiming seniority above us.
How were you appointed?
We are appointed after selection by the APSC as a direct recruit to the assistant engineer. So we have challenged the order of the Administrative Tribunal on the ground that, as per rule, they are direct recruited. They are entitled for seniority from the date of their appointment as the assistant engineer.
What does the rule say in terms of seniority?
Lordship, kindly see the rule. I have annexed, Lordship, page 61, starting from page 59.
61, yes. Rule?
Page 61, Lordship.
Yes.
Rule 4, sub-rule C. A member of Assam.
Rule 4. Yes.
Member of Assam Subordinate Engineers PW Service Rule service shall be eligible for promotion as assistant engineer subject to following condition. He has rendered minimum 8 years of service as a subordinate engineer and 1st February month.
No,
Second,
that sub rule 3 I'm unable to.
Sub rule 3 looks. C is the
number 2 is the description, definition.
Logic.
Then comes
C is the important.
cadre.
C is the important logic.
C, okay.
Notwithstanding anything contained herein above, subject to suitability, a subordinate engineer grade 1 of Assam Subordinate Engineering PW Service Rule on his acquiring academic qualification as prescribed for direct.
We are unable to be on the same page, sorry. You see these class 1, class 2, class 3, these cadres are described.
Lordship. So, Lordship, regarding direct recruitment.
Then
page 61, sub rule 4.
61, yes.
C, Lordship.
Yes.
C.
Yes.
Notwithstanding anything contained herein before, in this rule, subject to suitability, a subordinate engineer grade 1 of Assam Subordinate Engineer PW Service Rule on his acquiring academic qualification as prescribed for direct recruitment as an assistant engineer shall be promoted as assistant engineer in consultation with commission as provided in Rule 14 against next available vacancy in the cadre. Such promotion shall be treated as a direct recruitment in the cadre of assistant engineer. So we are also directly recruited in 2003, Lordship. They are recruited on basis of acquiring BTech degree in 2004. They want seniority above us. And that has been allowed by the Lordship, the administrator. That is the moot case.
So even your promotion is direct recruitment?
No, not promotion. We are direct recruiting. These are subordinate engineer, private respondent. Junior engineer. Diploma engineer. As per Lordship rules,
the rules say prescribed for a direct. Once you acquire the qualification, prescribed for a direct recruit assistant engineer shall be promoted as assistant engineer.
Lordship. And such promotion shall be treated as a direct recruitment. So they are claiming seniority above us.
Now, is there any prescription under the rules as to how this seniority is to be
Seniority
mentioned?
as per APSC's Lordship, the position, the seniority list.
No, under the rules, is there any
Lordship.
How seniority?
Lordship. Lordship will find page 64. Rule 22.
Yes, and Mr. Sharma, you are appearing for the private respondents who are claiming seniority over the petitioners. Then Mr. Dhar,
My lord, I will appear the department.
that we know. So are these respondents still available in the department?
My lord, I have gone through the
Gradation list.
gradation list, my lord. If they are still, they should be in service because they are now between age 50 to 53, 54. So they will be in service, my lord. Maybe some are executive engineers and super engineer, maybe.
And where is the judgment of the administrative tribunal?
Lordship will find at page
Huh?
at page 53, Lordship.
53.
Holding that they are promoted from 2003. Last portion. The conclusion reached by us with regard to the effect to be given, the promotion to the appellant to the cadre of Assistant Engineer Civil, and having held that such promotion is deemed to have been so affected during year 2003, the seniority of the appellant to the cadre of Assistant Engineer Civil is now required to be prefixed by the respondent in accordance with the provision of Rule 22(3) Sub-Sum Engineering Service Rules, Department 78, necessary exercise correction shall be made and required notification be issued, prefixing the seniority. That order has been stayed by this honorable court. Court held that in 2003 they have acquired BTech degree, so they are entitled to promotion from 2003. That is
And
the-
when were you promoted?
we are appointed, not promoted.
Already appointed?
2003
2003.
by APSC selection. Lordship will find the APSC selection. We are appointment letter also we are next.
Which month?
We are appointed in 26 2003.
And the respondents?
Respondents were junior engineer. They are being recommended for promotion. Lordship will find the recommendation.
Their basic case is that the vacancies in which they were promoted or appointed also pertains to 2003.
Notification page 35. Third January 2004.
Page number?
Page number 35. Page 34 is the original order. The Governor of Assam is pleased to approve the select list in respect of the following junior engineers PW in order of preference for promotion to the rank of Assistant Engineer Civil PW as per decision of the recommendation of the selection board. Meeting held on 26/12/2003, subject to completion of administrative formality. That is of January 2004. And minutes of the selection committee, page 33. Type copy, page 33 onwards. They are recommended on 26/12/2003.
Where is the Notification dated 3/1/2004.
Page 34,
34.
Annex 5.
Thirty-four or 35?
Page 34 is the type copy of it, and 35 is the 34A is the original copy.
Where is the minutes of the selection committee?
But you will find as page 33. Type copy. And original copy is page 33.
Where does it say it requires APSC approval?
Lordship.
Under the rules? Under the rules, where is the prescription that it has to be undertaken through the APSC?
We have not challenged their promotion, Lordship. We are claiming only that they, on the basis of recommendation of 2004, they cannot claim seniority over us. APSC has nothing to do because we have not challenged their promotion. We are claiming that they cannot be above us on the basis of administrative commission order.
Okay.
With consultation of with APSC, Lordship, page 61. Shall be promoted to assistant engineer in consultation with the commission.
61.
Page 61, rule 4, sub rule C.
Under rule 14.
Sub rule C. Shall be promoted as an assistant engineer in consultation with the commission as provided in rule 14 against the next available vacancy in the cadre, and such promotion shall be treated as adequate.
Yes. Yes.
Lordship, today I'm handicapped, Lordship, so Lordship may kindly accommodate for 2 weeks at least.
Nothing to be handicapped. We are just exercising our jurisdiction to see the correctness of the administrative tribunal order.
I'll assist your lordship only after 2 weeks. Lordship.
Not 3 weeks, next week.
2 weeks, lordship.
You go through and tell us next week.
I cannot also enforce that his senior is elevated. I cannot enforce it.
You cannot, we can. Therefore, we are keeping it on next week. Let the matter be listed on, matter be taken up next week. Enabling Mr. MP Sharma to complete his instruction. Appearing for respondents, so and so, private respondent. Mr. S.K. Goswami appears for the petition. Yes. Mr. R. Dhor for PWP department. Another casualty? No. Yes, yes.
In this matter, my senior already completed his submission. My largest senior
Completed his submission. What are the submissions? Give us, take us through.
This matter pertains to lordship denial of promotion, lordship. This is the second round of litigation, lordship. In the first round, lordship, on the basis of uncommunicated APAR, lordship, wherein the required mark was 60, I was allotted 59. My promotion was denied. The earlier order is at lordship page 11 is at page 120, lordship. Page 109 is start, sir.
Okay, we'll continue at 2 p.m. 2 p.m. Yes, yes. We'll continue at 2 p.m.
Yes.
Mr. Dotto.
Well.
Yeah, cool. Yes, Mr. Mazumdar.
This is a writ petition, my lord.
Removal from service.
Yes. Service. I think it was again fixed for that he was serving in the Central Reserve Police Force as a constable. Thereafter, he went on leave. While returning back from leave, when it was refused to be extended, an incident occurred at a railway station where he was arrested, and he was in custody for a certain period of time before he was granted bail. On reporting back to the department on bail, the department issued him a memorandum of charges. Along with putting him under suspension, a memorandum of charges containing 2 charges. First charge was that he was found in an intoxicated condition in a railway station, which is a misconduct as per the Act and rule. And the second charge that was given to him was that he failed to inform the authorities regarding his arrest. Now, the disciplinary proceeding continued, and at the end of the day, he was removed from service. That is what we have challenged, majorly on 2 grounds. One, that even if it is found that I was in an intoxicated condition, which was not proved in the departmental inquiry, there is no proof of it. Yet, if it is assumed, it does not fall under the misconduct laid down in the Act and rule. When I am found in such a state, then I am not on duty. I was on leave at that period. I had not prepared for duty. Admitted to me. The second, my lord, second limit argument for the other misconduct is that there are statements of witnesses which say that I gave them the information regarding my appointing authority and my authority under which I am serving, and it was because of that they had informed the authority.
Where is the charge sheet first?
Charge sheet, my lord, I had lost it, my lord, but if lordship will have the inquiry report, that is at page 19. It contains the charge. The Hindi version is also there. I am referring to the translated portion, my lord. Point number 2 is article number 1. that the aforesaid number so and so has committed an act of disobedience of orders as defined in section 11(1) of the Central Reserve Police Force Act in its capacity as a member of the force, in that on 27/7
Only two charges.
two charges. These are the two charges, and I have been imposed the
According to you, it's a case of no evidence.
the first one is not a charge at all, on which I could have been charged. Although, my lord, I'll also show from different judgments that the procedure required to prove intoxication was not followed in the departmental inquiry. That is one aspect. Otherwise, not being a misconduct, it could not have been a charge against me. The second, my lord, will find that force number so and so committed a misconduct in his capacity as a member of the force, in that while the employee was arrested by the GRP, which the employee did not inform the department on his own and kept hidden.
If time permits, we'll take it up. The records are available?
Yes. May I please, your lordship? Lordship, in item number 21, standing counsel has not come yet, lordship.
You wait for 2 o'clock. Mr. Tiwari, any matters? We'll have to come back at 2.
Very well. Two or 3 days.
Yes.
I was referring to the charges against the petitioner. Lordship has page 19. Let me read the charges again, my lord.
19.
Page 19, my lord. That is a translated version. That the aforesaid number so and so Constable Anit Kumar has committed an act of disobedience of orders as defined in section 11(1) of the CRPF Act in his capacity as a member of the force, that on 27/7/14 he was found at the Fatehpur railway station public place in a state of intoxication, which is suggested by the FIR and medical documents. This act of the employee is a serious and punishable offense under the provisions of section 11(1) of the Central Reserve Police Force Act 1949. Second article is that force number so and so has committed a misconduct in his capacity as a member of the force, in that while the employee was arrested by the GRP Fatehpur pursuant to case number so and so under section 308/504, in which the employee did not inform the department on his own and kept hidden. Therefore, this act of the employee is an act of grave misconduct of negligence towards his duties or orders under section 11(1) of the CRPF Act, which is punishable under Rule 27 of the CRPF rules. Thereafter, my lord, this is a part of the inquiry report where the statement of different witnesses have been taken on record. Now, before I go to that, if lordship permits me, I would like to come to section 10 of the CRPF Act.
CRPF.
please.
One minute.
Find
One,
it at
one
page
minute.
number.
1 minute. Just a minute. Page number.
Page number 4. if it is possible. Section 9.
Yes.
Section 9 of this part relates to offenses and punishments. Section 9 says more heinous offense. Every member of the force who begins, incites, causes, or conspires to cause or join any mutiny. This is not one which we are related to, man.
This is not.
This is not what is the charge against. 9B, uses or attempts to use criminal force or commits assault on his superior officer, not that. C, shamefully abandons or delivers up any post or guard. D, directly or indirectly holds correspondence with or assists or relieves any person in arms against the state. Or, while on active duty, disobeys the lawful command of the superior officer, deserts the force, being a sentry, sleeps on his post. H, leaves his commanding officer or post or party. I, quits his guard, picket, or patrol. J, uses criminal force. Number, I was on leave. I was returning to the to my post on after from leave. That is an admin position. So I am not on active duty. I could not have been charged under any of these. K, intentionally causes or spreads false alarm or displays cowardice in the execution of duty. That is, those are more heinous offenses as defined in the Act. Then Lordship would find at section 10. Every member of the force who is in a state of intoxication when on or after having warned for any duty or parade or in the line of march. 10A is the only section which relates to intoxication of a member of the force is in a state of intoxication when on or after having warned for any duty or on parade or in the line of march. So if a person is only found intoxicated if he has been warned for any duties or he has been warned for a parade or he is on parade or in the line of march.
So if you are on leave, you can do anything.
So that part, yes, it will not
So if
be
you're
a
on
charge.
if you're on leave, you can do anything.
I can get intoxicated and
Get into fights, whatever.
Well, that fight, if it comes to a conviction part, then my lord, I will trouble because then the conviction will go against me. But if my lordship, I had placed just one or two judgments, if lordship permits, to show that if it is not there in the act, then it would not be open to the disciplinary authority. This is a judgment of 1984, my lord. (1984) SCC 1 is the judgment. The misconduct, alleged misconduct was almost the same, a case of drunkenness, and how the Supreme Court dealt with it, whether the drunkenness had to be within the premises or in the line of duty, and if it happened outside the premises or not in the line of duty or not during duty, what would be the outcome? Lordship may like to have page number 3, clause number 7. Clause number 6, page number 3, clause number 6. The question is, even if uncontroverted, the allegations of misconduct set out in the charge sheet extracted above would be covered by clauses 10, 16, and 30 of the standing order. In other words, upon their construction, what is the scope and ambit so far
as time, place, aspect is considered in clause 10, 16, 30 of standing order. Clause 10, 16, and 30 of the standing order read as under. 22. The following act and omission will be treated as misconduct: drunkenness, fighting, indecent or disorderly behavior, use of abusive language, wrongfully interfering with the work of other employees, or conduct likely to cause a breach of peace, or conduct endangering the life and safety of any other person, assault or threat of assault, any act subversive of discipline and efficiency, or any act involving moral turpitude committed within the premises of the establishment or in the vicinity thereof. This was what the charge was there. Lordship would like to page 5, para 30.
Yes.
After reading clause 10, Mr. So-and-so contended that the expression committed within the premises of the establishment or in the vicinity thereof can qualify only the expression any act subversive of discipline or efficiency or any act involving moral turpitude, but not the earlier portion of the clause. Numerous acts of misconduct have been collated in clause 10, such as drunkenness, fighting, indecent or disorderly behavior, use of abusive language, wrongfully interfering with the work of other employees, etc. Says Mr. Bhushan that these acts of misconduct are per se misconducts, that each one of them cannot have any correlation to the time or place where it is committed, and each one of them is an act of misconduct irrespective of the time and place where it is committed. Expanding the submission, it was urged that the drunkenness in such a socially reprehensible action, that if it is committed within the premises of the establishment or in the vicinity thereof, or anywhere else at any point of time, it would nonetheless be an act of misconduct comprehended in clause 10 and punishable under standing order 23. If this construction were even to be accepted by the the employer will have more power than the almighty state, because the state chooses to punish drunkenness in public place. But on the construction canvassed for, if a man consumes liquor in his own house with the doors closed and gets drunk, the employer can still fire him. If a man uses abusive language towards his close relation at his own house within closed door, the employer would be entitled to fire him, and this approach overlooks the purpose of prescribing conditions of service by a statute. To enable the employer to peacefully carry out his industrial activity, the Act confers power on him to prescribe conditions of service, including enumerating acts of misconduct when committed within the premises of the establishment. The employer has hardly any extraterritorial jurisdiction. He is not the custodian of general law and order situation, nor the guru or mentor of his workmen for their well-regulated cultural advancement. If the power to regulate the behavior of workmen outside the duty hours and at any place wherever they may be was conferred upon the employer, contract of service may be reduced to contract of slavery. The employer is entitled to prescribe conditions of service more or less specifying the acts of misconduct to be enforced within the premises where the workmen gather together for rendering service. The employer has both power and jurisdiction to regulate the behavior of workmen within the premises of the establishment, or for peacefully carrying out the activity within the vicinity of the establishment. Then Lordship may like to come to page 7. I'm sorry, my lord, page 6.
Yeah.
The paragraph, my lord, it is not numbered. The second last paragraph, just above paragraph 16. 15th line from bottom of the paragraph, my lord. Starts with the word volume 44, para 909. Page 6. The decision proceeds is the paragraph.
Yes.
There, my lord, if lordship would come from the top, in some in the middle, the first words are volume 44, para 909 to 9110. In the middle of the paragraph, the starting words of the line.
Yes, yes.
Yes. I'll read after page 50. It cannot be seriously questioned that standing order 22 is a penal statute in the sense that it provides that on proof of misconduct penalty can be imposed. It cannot be disputed that it is a penal statute. It therefore must receive strict construction, because for a penalty to be enforced, it must be quite clear that the case is within both the letter and spirit of the statute. If the expression committed within the premises of the establishment or in the vicinity, therefore given a wide construction so as to make the clause itself meaningless or redundant, the penal statute would become so vague and would be far beyond the requirement of the situation to make it a weapon of torture. A clause with a statutory flavor like legislation must at all clause be interpreted in such a manner that it would not operate as a rogue's charter. If any misconduct committed anywhere, irrespective of the time, place, content, where and when it is committed, is to be comprehended in clause 10 merely because it has some remote impact on the peaceful atmosphere of the establishment, there was no justification for using the words of limitation such as committed within the premises of the establishment or in the vicinity thereof. These are words of limitation and they must cut down the operation of the clause. Therefore, these words of limitation must receive their due share in the interpretation of clause 10, and clause 10 cannot receive such a construction so as to make the words of limitation wholly redundant. Then if lordship should come to the next page. Paragraph 18, my lord.
Paragraph
18 on the next page. In the middle of the paragraph, my lord, again the line would start with the word the assailant and the victim. Okay, fine. In the middle of the paragraph, the assailant and the victim is one.
in para 18.
Para 18, my lord.
Assailant, yes.
Yes, the assailant and the victim. Even where a disorderly or riotous behavior without the premises of the factory constitutes misconduct, every such behavior unconnected with employment would not constitute misconduct within the relevant standing order. Therefore, even where the standing order is couched in a language which seeks to extend its operation far beyond the establishment, it would nonetheless be necessary to establish causal connection between the misconduct and the employment. And that is the ratio of the decision, and not that wherever the misconduct is committed, ignoring the language of the standing order, if it has some impact on the employment, it would be covered by the relevant standing order. In order to avoid any ambiguity being raised in future and a controversial interpretation question being raised, we must make it abundantly clear and incontrovertible that the causal connection in order to provide linkage between the alleged act of misconduct and employment must be real, substantial, immediate, and proximate, and not remote or tenuous. Then lordship would like to come to page number 9. The last few lines, my brother, of the last paragraph, the last 3 lines starts with taken into account. Page 9, my lord. The last paragraph, third line from the bottom, taken into account. Third line from the below.
Which paragraph?
It will be this page is my lord, it doesn't have a paragraph. Page number 9. The last paragraph starts as lastly we may refer to.
Yes.
The last paragraph.
Yes.
Of that paragraph from the bottom, I am taking the third line. Taken into account is how it starts.
Yes.
As varying as what is prescribed. In short, it cannot be left to the vagaries of the management to say ex post facto that some acts of omission or commission now were found to be enumerated in the relevant standing order is nonetheless a misconduct, not strictly falling within the enumerated misconduct in the relevant standing order, but yet a misconduct for the purpose of imposing a penalty. Accordingly, the contention of Mr. Bhushan that some other act of misconduct which would be per se an act of misconduct, though not enumerated in the standing order, can be punished, must be rejected. So my first submission that I had made was in the offenses, more heinous offenses, less heinous offenses. Intoxication while on duty, even if found to be correct, is not an offense, is not a misconduct under the Act and rules, and therefore the first charge, even if we assume that it has been held to be proved, could not have been leveled against me, and they could not have relied upon such a charge to have imposed upon me the punishment of removal from service. Now, my lord, the charge itself, if I may again come back to page 19, Article 1.
Yes.
The first charge, if we read, how do they propose to, what do they depend on to say that I was in an intoxicated state? It says, he was found at the Fatehpur railway station or public place in a state of intoxication, which is suggested by the FIR and medical documents.
Medical
document.
What is that?
Now, if lordship would kindly have the medical document that they try to bring on record. That medical document will be available at page 9 of the affidavit in opposition. I did not have a copy of it. I could not annex it. It is at page 9 of the affidavit in opposition, filed by the respondent.
Page 9.
Page 9 of the affidavit. It's in
That's
Hindi,
in
my lord.
vernacular.
Medical legal examination form.
It is
of
in
injured-
vernacular.
My lord, only the top line is in vernacular. The rest of it, my lord, the English version is given immediately below the
Injury
vernacular.
form.
My lord, medical legal examination form for injured person. Then it is injury form. Then they have my name at the first row. Thereafter, lordship would find on the next page at page 10. It's handwritten, my lord. Lordship will find some swelling and some measurement of the swelling is given on the top paragraph of page 10. If lordship will have the last line of the first paragraph. I will read it. Alcoholic smell present on expiration. Lordship finds on the first paragraph. It's the last line of the first paragraph. Alcoholic smell present on expiration.
Not very clear.
That is how they have also stated in their affidavit question. Then if lordship has the down below nature of injuries, simple, fresh, just to that right, lordship it is written alcoholic smell present expiration. So the only test that was conducted upon me when I was arrested by the GRP
And
was
what is that
an
object
alcohol-
used?
My lord?
What is that object used?
Object is a hard and frigid from something. Hard and frigid.
Pardon?
It must be available in your record.
Yes, that is.
That is also a photocopy. The original was never produced in the department proceeding is one of my ground. They came up with photocopies. The doctor was never called to the disciplinary proceeding to say whether this is a medical report which he had given or not. Otherwise, also this alcoholic smell present on expiration. This was the only test done upon me to come to a conclusion that I was in an intoxicated condition when I was found in the railway station. For this, my lord, I would like to please yes. Judgment of the division bench of the Honorable Manipur High Court. This lordship, the legal citation is 2014 legal Manipur 109. WPC 498 of 2013, decided on 31st of July 2014. There, if lordship would have page 7. I'm sorry, my lord, page 6. It's not at page 6. Para 9.
Page 6.
Page 6 of the judgment, my lord, para 9.
Para 9.
Even otherwise also, while examining the inquiry report, it has been noted that though the inquiry officer has come to a finding that the petitioner was under the influence of alcohol, no finding has been made that the petitioner was in a state of intoxication, which is a specific offense, that is a less heinous offense, as mentioned at section 10A of the Central Reserve Police Force 1949. In this regard, one may refer to section 10 of the Act, which reads as follows. I had read it out. 10A is in a state of intoxication. Here, my lord, the allegation was that he was drunk when he was on duty. Lordship would have page 7 thereafter. Where the section ends, my lord, consumption of liquor is where the paragraph says. Consumption of liquor while on duty is one thing, and conclusive finding that because of consumption of liquor, the petitioner was in a state of intoxication while on duty, and the petitioner's normal capacity to act was inhibited and adversely affected, and the nature of duty has been compromised, putting the individual or the organization at risk is another thing. Consumption of liquor while on duty as per the CRPF Act is not per se an offense. unless one is in a state of intoxication while on duty. There is no finding to the effect that the petitioner
What is the
was in a
difference
state-
between consumption and intoxication?
Intoxication, my lord.
What is the
Intoxication.
difference?
And an intoxication, what I was once given to understand is is a state where after consumption, one loses inhibition and gives exhibition. So here, intoxication is something which was never proved. The expiration breath would only prove consumption at best. The finding rendered as in subpara 3 of the analysis and assessment of evidence is that the petitioner had consumed liquor while on duty. There is no finding by the inquiry officer that because of consumption of liquor, the petitioner had behaved in a manner which has seriously breached the safety and security of the organization. There is neither any finding that the petitioner was found in a condition of drunkenness or inebriation and was incapable of performing his entry duty. It is to be noted that as per the article of charge, the petitioner at the relevant time was alleged to be under influence of alcohol. Therefore, it may be necessary to understand the meaning of the expression under the influence of alcohol so as to appreciate the charge level against the petitioner and which had been held to be proved by the inquiry officer and the punishment imposed upon him based on the charge. It may be noted that under CRPF Act 1949, to be under the influence of alcohol itself has not been specifically mentioned as an offense or misconduct. What has been prohibited or specified as an offense is to be in a state of intoxication when on duty, as mentioned in section 10A of the Act. In other words, the petitioner was charged of being in a state of intoxication. When on duty, the department had to prove the same and could legitimately impose any punishment on the petitioner. Then Lordship should have down below the intoxication has been discussed. Then Lordship will find
No, but from where do you find the difference between consumption and intoxication?
Well, this is
are
where-
two separate things.
This is what Lordship will find. But one thing this judgment has made specifically clear is that consumption of liquor while on duty by the CRPF Act is not per se an offense unless one is in a state of intoxication while on duty.
No, what is the finding of intoxication
For us, there is no finding of intoxication.
in this judgment?
My lord, yes. Lordship will find
What is the meaning of
at
intoxication?
page 8, para 14. Page 8, my lord.
Intoxication, black.
Intoxication has been defined in Black's Law Dictionary. Intoxication term comprehends situation where by reason of taking intoxicants, an individual does not have the normal use of his physical or mental faculties, thus rendering him incapable of acting in the manner in which an ordinary, prudent, or cautious man.
Circumstantial, you are found to be involved in brawls.
Something has to be there. Brawl that.
You are involved in brawls
I have brought in
as a member of a discipline force,
I have brought in on
maybe on leave, and there was smell of breath on expiration.
My lord, the additional affidavit I have brought in the judgment of the trial court, which says that I was not the person involved in the brawl. That has also been brought on record. I was not the man who was involved in any brawl at the. No.
Okay. Let us go to that additional affidavit.
Yes. The additional affidavit, my lord, has been filed. March 2019, my lord. Their lordship will find the judgment starts at page 8.
Page
8 of the additional affidavit. In fact, in that proceedings, the allegation that I was under any influence of alcohol is not there at all. Although the Railway Act makes it an offense, and if I was found in an intoxicated condition, the GRP had to lodge an FIR that I was in an intoxicated condition. That FIR never came.
So the FIR was for what purpose?
My lord, someone lodged an FIR that I had pushed him from the train when I was intoxicated.
Where is the judgment?
My lord, at page 4 of the additional affidavit.
Page 4
of the additional affidavit. It starts. My lord, page 8 onwards is the original version.
Okay.
Page 4 is the translated version. Lordship will find I am the accused number 2. Lordship will have page 5. I have heard the arguments of the learned in the last paragraph, and the first information before. I start from there. The first information report is the basic document of prosecution. The FIR was registered on the basis of written complaint lodged by the complainant Sambhu Yadav with the officer in charge of the GRPPS. And as per the contents of the written complaint, the case is that on 27/7/15, the complainant Sambhu Yadav and his brother Sanjay Yadav were coming to their house by train number so and so, that the accused duo traveling by the same train asked them to vacate the seat and leave the train, and started rebuking them. That they kicked the Sanjay Yadav, the brother of the complainant, that he consequently he fell down from the train ahead of Vindki railway station, and that the brother of the complainant sustained injuries on head. To sum up, as per the written complaint, the complainant is a directly affected person and he is the eyewitness of the incident. Both of them were examined by the prosecution. As regards the evidence of PW2 Sanjay Yadav, the victim, he stated in his examination in chief. Medical examination. I'm sorry, madam. As regards the evidence of PW2 Sanjay Yadav, the victim, he stated in examination in chief that there was a crowd in the bogie, and owing to that, he was standing near the gate. That when the train was nearing Binti railway station in slow motion, someone pushed him from behind, and owing to that, he fell down from the train and sustained injury. That the accused persons neither assaulted nor kicked nor rebuked him, and that in the crowd, someone pushed him and consequently he sustained injury. The evidence of this witness does not prove the story of the prosecution. On the request of the prosecution, this witness was declared hostile. But in the long cross-examination by the learned assistant district government advocate criminal, no specific element proving that the witness is deposed false to save the accused person has been found. Similarly, the complainant Sambhu Yadav was examined by the prosecution witness number 1. Evidence of this witness also does not prove the case of the prosecution. The witness was also declared hostile, and as per his statements too, there was a crowd in the bogie. They were traveling, standing near the gate. In the crowd, someone pushed his brother, and owing to that, Sanjay fell down and sustained injury. The accused person present in the court neither assaulted nor felled his brother by dealing kick. The written complaint has been exhibited as Exhibit 1, but the witness stated in his deponent that he got it written by Indal Kumar, and that he did not got it written about the assault and rebuking by the troopers or servicemen. Witness Sagar Burman was discharged on the basis of petition by the complainant and on the satisfaction of the learned assistant district government advocate. After the accused person accepted the validity of the documents, the evidence of the prosecution was closed. Thus, the evidence of both the PWs, that is the victim and the complainant, does not prove the case of prosecution. No other witnesses were examined by the prosecution. On the basis of the above discussion, it is clear that the prosecution has failed to prove the charge framed against the accused persons for committing offences punishable under 3034504 beyond reasonable doubt, and accordingly the accused persons are liable to be acquitted. Accused persons are acquitted from the charges framed against them. Accused persons are on bail. Their benefits and CRPF papers are vacated and the accused discharged.
Okay. What was the second charge?
The second charge, Lordship, will find at page 19 that force number 1152 has committed a misconduct in his capacity as a member of the force, that while the employee was arrested by the GRP Fatehpur pursuant to case number 38 of 14, which the employee did not inform the department on his own and kept hidden. Therefore, this act of the employee is an act of grave misconduct or negligence towards his duties under section 11(1) of the Central Reserve Police Force Act, which is punishable under section Rule 27. My lord, my arrest is on 27. This just below the synopsis, my lord, I have given a list of dates. My arrest was on 27/7/2014. On 28/7/2014, the Railway Police Force intimate my employer that I have been arrested by them and taken into custody. On 8th of August 2014, based on that piece of information, I am placed under suspension with effect from 27th of July 2014. I am granted bail on the 5th of August 2014. I report to my duties on 13/8/14. The suspension was revoked on 26/8/14. And the departmental proceedings started on 21/11/14. If Lordship has, in the same inquiry report, if Lordship has the statements of the witnesses at page 23, ASI Ministerial Mukund Chand of the Recruitment, my lord, page 23. ASI Ministerial Mukul Chand said that around 10 hours on 20th/7/14, information given from the GRP police station Fatehpur and simultaneously from the office of the Inspector General Central Sector dated 20th/7/14 that force number so-and-so Anit Kumar has been arrested by the GRP Fatehpur. Now, once a man is taken into custody, the allegation lordship will find in the other statements, the witnesses have stated at page 21, if lordship would have, just prior to the statement of the witness number 2. They say the witness further stated that the accused did not inform about his arrest by the GRP at Fatehpur or regarding his being sent to judicial custody either by phone or by any letter.
So let us assume that you were arrested.
Yes.
Under what provision is it to be construed as a misconduct?
But here in the CRPF Act, there is no provision that once I'm arrested, I should inform the department. If we again go through the section 9, section 9 was more heinous offense while on duty if I do something very heinous. Less heinous punishments, my lord, less heinous offenses. The first is of intoxication. Second is striking or attempting to strike a sentry. Then C is being in command of a guard. I'm not there. Being under arrest or in confinement, leaves his arrest or confinement before he is set at liberty. I have not done that. Is grossly insubordinate or insolent. That is not there. Refuses to superintendent is not. Strikes or otherwise illuses. Designedly or through neglect injures or losses or fraudulently disposes his arms or clothes or tools. Malingers or faints or produces disease or infirmity in himself with intent to render himself or any other person unfit for the service of the force, voluntarily causes hurt to himself, does not when called upon by his superior officer to do so, or ceasing to be a member of the force forfeit, deliver up or account for all arms and ammunition. L, knowingly furnishes false return or report to the number and state of arm any man under his command. M, absents himself without leave. N, is guilty of any act or omission which, though not specified in this act, is prejudicial to good order and discipline. O, contravenes any provision of this act for which no punishment is expressly provided for, or who, while not on active duty, commits any of the offences of E12 in section 9. E12, if not on active duty, if it disobeys the command or anything, then those things will come in, it becomes a less heinous. So at best, my lord, they may try to draw a reference to 10N. 10N is guilty of any act or omission which, though not specified in this act, is prejudicial to good order and discipline. The judgment of the Supreme Court, Honorable Supreme Court that I just read out, my lord, says, even if it is such an act, some correlation to the immediate correlation to the duty must be shown, to his official position must be shown to bring it into the garb of a misconduct. Here the situation is 27th I am detained, 28th they are informed by the GRP. The only person to tell the GRP that I serve in such and such and please inform my family or my employer is the person himself. The information goes from the GRP. I am released on, my bail order comes on 5/8.
After release, where were you?
5/8, my lord, the bail order is there. 8/8 they place me under suspension. 13/8 I report. 5/8 was, my lord, when the bail order was passed. 13/8 I reported there. Sometime to get my bail, sometime to go to my home, gather my belongings, because I have stated also here also in the DP that all my belongings were stolen. So whoever took me out on bail, I had to go home, gather my things, come back and report. It took me around 5 days. If I'm released,
They were already stolen. How can you gather it from your residence?
No, I'll have another piece of shirt or another piece of something in my home.
So
go back to
you were granted bail on?
The order is of 5/8/2014.
5/8.
2014.
Bail granted.
Bail granted. I am placed under suspension by order dated 8/8/14 because of the communication dated 28/7/14.
Communication dated.
I was placed under suspension from 8/8/14 because of the communication dated 28/7/2014. My arrest is on 27/7/14. That is in evidence.
All right.
On my reporting back, on 26/8, the suspension is revoked. And that suspension could have been revoked only, my lord, when I produce that bail order that I am here with authority. Otherwise, my lord, Section 10D would have come into play. Being under arrest or in confinement leaves his arrest or confinement before he is set at liberty. I was set at liberty on my bail. I reported back on duty on 30th. And the charge sheet comes, my lord, on 21/11/2014.
Charge sheet in the criminal matter.
No, my lord, the memorandum of charges in the disciplinary matter. And I'm acquitted of my charges in the police case. That is on 11/7/2016. And I was removed from service on 33/15. The acquittal is after the removal.
Removal is from?
Removal took place on 30/3/2015.
You filed an appeal also?
My lord, the departmental appeal, no, my lord, departmental appeal was not.
Why? Why not filed? Revision is also there. Is there a provision for revision also?
Yes, there are, but there are judgments, my lordship allows me sometimes. There are judgments of this honorable court, my lord, notwithstanding the provision of an appeal or a revision. This, my lord, the repetition of 15.
That is once we come to a finding that the very initiation is not in consonance with the provisions of the Act. But we have to come to a finding prior to that. All right. Yes, anything more?
My lord, I'll reply.
Reply.
Yeah, madam. There are two articles, madam. Article, may I read Article 1, madam? That the aforesaid force number so-and-so Constable C.D. Anit Kumar of F48 BN has committed an act of disobedience of the order as defined in Section 11(1) of the Central Reserve Police Force Act in his capacity as a member of the force in that on 27
Did you first put in the questions necessary under Rule 27(4) C4?
Yes, sir.
Is it evident from your inquiry reports? 27C4.
27. The accused shall leave examined and his statement recorded by the officer conducting the inquiry. If the accused has pleaded guilty and does not challenge the evidence on record, the proceedings shall be closed for orders. If he pleads not guilty, he shall be required to file written statement and list of such witness as he may wish to cite in his defense within such a period, which shall in any case be not less than fortnight as the.
Is it available? Is it seen from your records?
Yes, my lord.
Is this question be put to him?
Yes, my lord.
I don't have to see it, just asking you.
Yes, ma'am, that
It
has
is
been there.
there.
It is there.
That is discussed in the inquiry report also, property.
But Article 1, my lord.
No, what do you say to his submissions? He is twofold. Number one,
Yes.
that it is not a misconduct. It is
Yes.
not defined under the instances described under the Act.
Yes, my lord.
That it is not a misconduct because he consumed.
Yes, ma'am.
There is no evidence to say he was intoxicated. Number one. Number two, assuming he had consumed or assuming that he was intoxicated, it was while he was on leave, not on active duty.
Yes, ma'am.
And number two, that it is he who furnished the information to be sent to his superior officers. Therefore, charge number two also cannot be attributed to him to be a misconduct.
Yes, ma'am. My lord,
So, what is your stand?
yes, in this regard, my lord, I'm just so that that's why I'm reading article number 1, my lord. He suggested that medical document and this act of the employee is a serious and punishable offense under the provision of
Medical document which is relied upon is only a physical examination.
My lord, from the question was asked to the delinquent, my lord, and he had pleaded guilty for article number 1, my lord.
Ah. Where is that?
That is, my lord, this is the original record, my lord.
No, it must be available here somewhere.
They are also stated in that inquiry report also, my lord. That is in,
Okay, you mark it. You mark it.
yes, my lord.
Like mark it. Is there a page number available there?
Yes, page number 66 of the original record, my lord.
66.
66, my lord.
Yes.
Yes. Means, my lord, he has pleaded guilty, my lord. If we read section 11, my lord, section 11(1), my lord. The commandant or any other authority or officer as may be prescribed may subject to any rule made under this act award in lieu of or in addition to
No,
suspension.
that is minor punishment.
Yes, my lord.
In addition to minor, you can impose major.
Yes,
That is
my
your
lord.
submission.
Yes.
But before you impose a punishment,
Yes.
you have to show that it is a misconduct. Misconduct will have to be described.
My lord, he had pleaded guilty, my lord. That
No,
is
he has pleaded guilty to what?
that he was intoxicated on that day.
Exactly. So show us from your section
Yes, my lord.
that
From-
intoxication on
Is a
leave.
offense.
No, intoxication per se is an offense, or intoxication is a misconduct,
Yes,
or
ma'am.
intoxication even on leave is misconduct.
My lord, here, my lord, in section 11, my lord, this is regarding the manner. Kindly see, my lord, in section 11 in the suspended and following punishment to any member of the force whom he considered to be guilty of disobedience, neglect of the duty, or remains in the discharges of any duty or other misconduct in his capacity as a member of the force, my lord.
What is that
So-
other misconduct?
My lord, though that has not been prescribed, my lord, it is a misconduct, my lord.
No. How can you? That would be highly arbitrary. That you pull up somebody and say you're guilty of some misconduct. I punish you. How can you do that? Misconduct will have to be defined. You will have to drive home the argument
Yes, ma'am.
that intoxication or consumption, notwithstanding that he was on leave, will be a misconduct under the provisions of the rules or act.
Yes.
Or some circular.
That is not in that act, my lord. I don't have the knowledge about the circular. but
Exactly,
it
that is what we are
not
asking
in that
you.
act,
It is
my
not
lord.
there in the act.
The act is in intoxication, Mr. That is not in that act, my lord. While he is in leave, he was in leave, my lord. But there is a misconduct in the capacity as a member of the force. And my lord, in section
No. Misconduct in the capacity has to relate to section 9 or 10. Is there any other definition of misconduct?
misconduct, my lord. Active duty clause. Definition is not in the act, also in section 2, my lord. Okay, beauty.
Hmm?
Eleven nine, my lord. There is also 11.9, my lord. Section 11, sorry, my lord. Section 10.9, my lord.
10,
10.9.
section 10.9,
Sorry, N, my lord.
N.
N. Is guilty of any offense or omission which, though not specified in this act, is prejudicial to good order or discipline, my lord.
All right.
Discipline, my lord. This is not order but discipline, my lord.
Yes, please.
Then, my lord, who is guilty of, my lord, section 10 or section 9 and 10, my lord, the punishment is that under section 11, my lord, punishment is that in addition to the suspension, dismissal, or any or more of the following punishment, in addition to the suspension or dismissal may be imposed upon the delinquent, my lord. And for that, my lord, I have the judgment of Supreme Court, my lord. That is dealt with, my lord, section 11 for punishment for removal from service, my lord. Here, my lord, offense is different. That is overstay, my lord. But our offense is different, my lord. Fact is different, but my lord, from the last para of first page, my lord.
Yes.
Here, my lord,
Last para of
last para of first page, my lord. Learned Additional Solicitor General appearing for the appellant submitted that view taken by the High Court is clearly indefensible. It was submitted that section 11 did not provide for any minor punishment. It provided enumerated punishment were in lieu or in addition to order of suspension. It provided that enumerated punishment were in lieu of addition to the order, suspension, or dismissal as case may be. Rule 27 clearly permitted the order of removal from service and no interference by the High Court was called for. There is a no appearance on behalf of the respondent in spite of service. My lord, the scope of ambit of section 11 and rule 27 has been called and determination in this appeal. A few provisions having relevance need to be noted. Undisputedly overstay without sanction leave, that is, my lord, regarding their offense, my lord. It relates to the lesser punishment. Section 11.1 of the Rule 27 read it as follows. Section 11.1 is the punishment for addition to that may be imposed, dismissal or that is Section 11, my lord. That is regarding the punishment.
But is there a finding by
The finding is that, my lord, kindly see page number 5, my lord. From last page of page number 4, my lord.
Yes.
Last para of page number 4, my lord.
Page 4.
A bare perusal last line, my lord.
Last para, yes.
A bare perusal of section 11 shows that it deals with the minor punishment as compared to the major punishment prescribed in the preceding section. It laid down that the commandant or any other authority or officer as may be prescribed may subject to any rules made under this act awarded any one or more of the punishment to the any member of the force who is found guilty of disobedience, neglect of duty, reminiscence or the discharge of duties or other misconduct in his capacity as a member of the force. Accordingly, the High Court, the only punishment which can be awarded under this section are reduction in the rank, fine, confinement to the quarter, and removal from any office of the of the distinction or special special emolument in the force. In our opinion, the interpretation is not correct because the section says that this punishment may be awarded in lieu or in addition to the suspension or dismissal. They use the word in lieu or in addition to the suspension and dismissal appearing in subsection 1 of section 11 before the clause A to E shows that authority mentioned therein are empowered to award the punishment of dismissal or suspension to the member of the court who is found guilty, and in addition, in lieu thereof, the punishment mentioned in clause A to E may be awarded. It may be noted that section 9 of the Act mentions serious or heinous offense and also prescribed penalty which may be awarded for them. Section 10 deals with the less heinous offense, and clause M, our is clause N, my lord. Clause N therefore shows that absence of a member of the force without leave or without sufficient cause, overstay without sufficient cause is also mentioned as less heinous offense. And for that also a sentence of imprisonment is provided. And it is also therefore clear that Section 11 deals with only those minor punishments which may be awarded in the departmental inquiry, and plain reading therefore makes it quite clear that punishments of dismissal can certainly be awarded thereunder even if the delinquent is not prosecuted for an offense under Section 9 and Section 10. It is fairly settled that opposition in the law removal is form of a dismissal. That is, my lord, in this court, Dr. Mahadev Nadarkini versus Municipal Corporation Bombay explained that removal and dismissal from service stand on the same footing and both being about the termination of service, though every termination of service does not amount to removal or dismissal. The only difference between two is that the case of dismissal, the employee is delinquent from the future employment, while in the case of removal, he is debarred from getting future employment. Therefore, dismissal has more serious consequence comparison to the removal. In the event of Section 11(1) refers rules made under the Act and under which action can be taken. The Rule 27 is part of the rule under the Act. The Rule 27 clearly permits the removal by the competent authority. In the instance that commandant who had passed the order, removal was competent authority to pass the order, my lord. Yeah, my lord. The Supreme Court clearly says that the dismissal or removal can be imposed in lieu of, in addition to section, subsection A to E, my lord.
No, that's correct. But
Yes.
but where is the finding? What is the ratio of the judgment that notwithstanding misconduct not being prescribed, dismissal can also be imposed?
But here, my lord,
The issue here is that whether, in addition to the minor punishment,
yes,
removal can be
yes, ma'am.
imposed.
Yes.
That the court upheld here.
That is, my lord,
But the question is, you are imposing punishment for a misconduct.
yes, my lord.
What is that misconduct?
Misconduct, my lord, in section 11 and my lord, is guilty of any act committed which, though not specified in this act, is prejudicial to good order or discipline, my lord. He is a person of disciplinary force, my lord. Then he is my lord, he is guilty of, my lord, a prejudice to good order, or that is prejudice to the discipline, my lord. And he had pleaded the guilty also, my lord.
No. He all these acts which he committed
Yes.
is not an act which he committed in while on duty.
Yes, not in duty.
Not in duty.
Not he is at that time he was not in duty, my lord. That is,
He was on leave.
yes, my lord.
It's not a case of what do you call it? Being absent without leave.
Yes, or that is not the case of
That is not a
absent,
case.
that is not-
His leave has been sanctioned.
Yes,
He
ma'am.
was on leave.
Yes, ma'am.
There is an allegation against him, which allegation apparently subsequently has been held to be, he's been acquitted. That there is no evidence. So on what basis was the proceedings drawn up against the petition?
My lord, there is an the evidence of the police officer also, that is page number
No, so therefore you'll have to,
page 23, my lord.
you will have to show us that police officer is not competent to say that a person is intoxicated without any material. There has to be a medical examination. Was the doctor examined? Perhaps not. No. Doctor was not examined.
Doctor was
Even the original was not
The
executed.
original
Medical report was not
medical
got.
document was not there. So your basis to impose the punishment. This judgment is an authority that besides minor, you can impose major punishments. We are with you on that.
Yes, ma'am.
But before you want to impose punishment, you must establish a misconduct.
My lord, kindly, case number 23, my lord, of repetition.
Yes.
That is, my lord, Brijesh Kumar, inspector and officer in charge of GRP PS Fatehpur, my lord. Sri Brijesh Kumar, inspector so and so said that Sambhu Yadav, son of Yogal Yadav, village so and so, had lost a written affair that he was traveling with his brother Sanjay Yadav in the general bogie in train number so and so in Northeast Express. In the same bogie, two army men asked them to leave the seat and got down from the train. When two brothers left the seat and came near the gate, the both of army men came towards them using the vulgar language and kicked his brother Sanjay out of the train. The train was stopped by pulling the chain. When the train stopped the Fatehpur station, then he reached the train along with the complainant. Then the complainant identified Anit Kumar and Ramdas Singh as the army men who had pushed them. Both the accused were taken into the custody by the employee of GRP. Anit Kumar was taken for medical inspection at 17.35 hours, which confirmed consumption of alcohol. The witness further stated that when Anit Kumar was taken into custody,
No
he
medical examination, but what was the result of the medical examination?
medical examination, mother, that is case number 26, madam. Document number 9. Mm, 24. Madam, page number 25, madam, medical document. Page number 25, page number 24, summary of evidence and presented by the prosecution. Page number 25, 9, my lord. Copy of the medical legal examination from in the form of for injury person, serial number 10 district hospital. The document is 2 pages, according to which at 5.35 hours in the evening on 27, Anit Kumar was medically examined where injury marks were found on the nose, lips, and forehead, and shoulder, and alcohol was present, my lord. And I'll flag mark that medical document in original record, my lord.
Yeah, right.
Then page number 26, my lord.
Yes.
Page number 2613. The document is one of the page according to which the Superintendent of Police Allahabad had informed the Additional Director General of Police Railway on 27/7/2014 GRP Fatehpur had arrested Constable Anit Kumar. Accused Anit Kumar was in an intoxicated condition. On medical examination, alcohol was present.
Yes.
My lord, that is regarding the first article, my article of SARS, my lord.
Yes.
Oh, that is. My lord, here, my lord. That question was asked to that delinquent, my lord. That is in Hindi, my lord.
Hmm?
That is in Hindi, my lord. You
Page number?
Page number 66, my lord. Here the question is that ये कि बल नंबर सो एंड सो अनित कुमार बटालियन CRPF अधिनियम 1914 की धारा 11(1) की अधीन बल का सदस्य होने की हैसियत से आदेश की अवहेलना का अपराध किया, जिसके अंतर्गत क्रमिक दिनांक 27/2013 को फतेहपुर रेलवे स्टेशन पब्लिक प्लेस पर नशे की हालत में पाया गया, जिसकी पुष्टि प्रथम
This is what a medical report.
that is that he had pleaded guilty. That question was asked to him, my lord.
How? That
Maybe
is at page number
page number 66, my lord.
66. Okay, yes.
Of my lord.
Of the records.
Of the record, my lord.
Yes.
नशे की हालत में पाया गया, जिसकी पुष्टि प्रथम सूचना रिपोर्ट एवं मेडिकल दस्तावेजों से हुआ। क्रमिक का ये कृत्य CRPF अधिनियम 1914 की धारा 11 के अंतर्गत गंभीर और दंडनीय अपराध है के लिए आपने अपने आप को दोषी मानते हैं या नहीं? जी हाँ श्रीमान, मैं अपने आप को दोषी मानती हूँ। That is, my lord, he pleaded guilty, my lord. And regarding the second article, my lord, article of SARS, my lord, that is the statement of officer has already been taken, my lord, during the inquiry process. That is page number 20. I have already read, my lord. He was not in a position to give that is in page number 23, my lord. That he was in a dangerous intoxicated state and he did not attempt to give any information to any higher official regarding his arrest. Further, he said that he was from that it was from the identity card that his posting of the accused could be determined, my lord.
The identity card you have posting.
The identity card, yes, the details. And then the posting of the accused, my lord, where he was posted at that point of time, my lord.
This is at page number?
Page number 23, my lord. Of which petition, my lord? That is statement of inspector in charge.
From your records.
From record, my lord. Tag mark it, my lord. Record, my lord, page number. Kumar.
This is evidence of?
Evidence of Brijesh Kumar Yadav, inspector and officer in charge, CRT PS Fatehpur, my lord. In record, my lord, that is page number. I'm giving that page number of this evidence, my lord. I'm giving. But my humble submission is, since he had pleaded guilty for article of SARS number 1, my lord, that punishment has been given under the Act section 11, and that was that under section 10, my lord, that was defined in under section 10(9), my lord. Guilty of, my lord, order, not order, the discipline, my lord. And my lord, second submission, that there is evidence of the inspector of CRPF that he was not in a position to inform the position to deliver any about the information of himself, my lord. So they came from his identity card only, my lord. He was not in position, my lord. And intoxication is an, my lord, since he is a member of the, my lord, disciplinary force, my lord, that is come under section 11, section 10(n), my lord, clause N, my lord. And under section 10, and under section 11, my lord, punishment can be given, my lord, in addition to other punishment and removal from service also, my lord. That is my submission, my lord.
Okay.
I'm giving the page number of this, my lord, statement of CRPF officer, my lord.
Yes, Mr. Mazumdar, any resume?
The statement of Rajesh Kumar, Inspector and Officer in Charge, GRP Fatehpur, whose statement is the only statement on record to say that I was in an intoxicated condition when I was arrested by them. Contrary to this, my lord, the orders passed, the orders which had acquitted me, my lord, in my additional affidavit, which I have given the judgment of the Honorable Court.
We are examining a disciplinary proceeding.
Yes, yes.
So therefore,
No,
the yardstick in a criminal case
It will be
and
very different, but
disciplinary are different.
since this has been brought up, and so that it does not have an adverse consequence.
But you admitted to the judges.
I'll show my lord what has been admitted, why it has been admitted, how it will be read, my lord. Now, when the evidence of the inspector who arrested me is taken on record, who goes in detail to say that these two men came, these two men complained about this man, and that he had pushed them out, he was identified, we arrested. The complainant says before the Honorable Court, the written complaint has been exhibited.
Oh, you're going back to the criminal case.
I'm just so that my lord, it does not
No,
influence.
what we want to know.
Yes.
We are not here to see the sufficiency of
My lord,
evidence. We are here to just examine whether there was some material to come to this finding. Now, in the face of your admission before the authorities,
to the
you've
extent,
admitted
to the
that
extent,
yes, you were.
No, to the extent, lordship will see to the extent that whether I was drunk, whether I was intoxicated, I admit.
What is the
even if I go
what is the equivalent term of Hindi in intoxication and consumption and consumption of alcohol?
I would say, my lord, daru pi hui hai.
Whatever. The question is that you have admitted that yes, you had undertaken. Number one, this is not a case that you were caught hold of from a family function or something like that.
Yes.
You were traveling in a train. There is an accusation that you caused a ruckus, threw somebody out, etc.
Yes.
Now, whether these evidences are finally brought home in a criminal court or not is one aspect of the matter. The other aspect is, on these circumstances, are these two allegations found to be correct? Allegation one, you have admitted.
It could have, whether it could have been an allegation at all.
It is. In a state of
intoxication on duty.
No. You have not brought evidence to show the quantum of consumption.
Whether I was on duty, whether my consumption.
See, that analogy will create havoc, Mr.
That is what the Supreme Court has said. If that is not taken into account, it will create havoc. Lordship will just permit me, my lord, once more. I will go through that particular Supreme Court.
Now, Supreme Court we have seen.
How, my lord, the
Supreme Court judgment is with regard to standing orders.
My lord,
we are now dealing with members of discipline forces.
My lordship, we are dealing with an act.
We are, but there is a judgment of the apex court where it says that discipline is an inherent requirement of a discipline.
The honorable
disciplinary of a member of a discipline force.
Lordship permits me.
Non-negotiable.
I do not have the judgment on me right now, but there is also a judgment of the Honorable Supreme Court which says that when a penalty is being imposed on a person, it cannot simply be that he is a disciplined and we have to be more strict in everything with him. He remains a human.
No, quite right.
He remains a human, and if he has done a dereliction on duty, then there should be no mercy at all. But if it is not a dereliction of duty, with the same strict measures,
you produce the judgment.
That judgment I will bring on. Now, yes, my lord, one I have got. This judgment which I referred, our honorable High Court's judgment, my lord, single judge. The charge of an uniformed person coming to attend duty in an intoxicated state is a very serious charge. In view of the seriousness of the charge, it is incumbent upon the authority to have carried out a medical examination of the petitioner. Merely on the basis of presumption and suspicion, it could not be said that the charge of the petitioner being in an intoxicated state while reporting for duties to prove. These are even when a person reports to duty when he is intoxicated. Present particular case is one where on coming back from leave, the accusation is only by one person, the GRP police, that I am in an intoxicated condition. This intoxicated condition is not while I am on duty. The Central Reserve Police Force Act and rules does not for once make such an act an offense. And in fact, if Lordship will kindly have one part of it, I will just show one part of it. My leave certificate, if Lordship will have for a moment, which they have attached. If I'm not wrong, the leave certificate. I had attached it. I'm sorry. It was the leave certificate. That has not come in, my lord. I'm sorry. The leave certificate itself says he is allowed to carry so many bottles of whiskey and rum while on journey. So, meaning that one of the leave certificate
In fact, this was a query which I wanted to ask.
My lord, yes.
Is that as a member of a discipline force, you are entitled to a specific amount of specific quantity of supply?
It cannot be said that my consumption anywhere will simply become a misconduct on my part if I'm found anywhere under consumption.
You bring it on record later.
That leave certificate.
Saturday? You get it on record? Show us a copy.
Of the leave certificate.
Monday, Saturday. Monday, na kali korilega na. Tomorrow, my lord.
Tomorrow, no, tomorrow. I may be able to fix it.
Tomorrow at 2, my lord. That is only to a question of you. You have a certification anymore.
Why not on Saturday?
Well, I have some difficulty on Saturday.
You ask your colleague to be present?
Yes, ma'am. That can be. Yes, ma'am.
To ask your colleague to be present?
Yes, well, that is page number 41, madam.
41.
Yes, madam.
Oh.
That statement of inspector on officer in charge of GRP.
Page number?
Page number 41. I have marked it, ma'am.
You said 23?
No, 41, ma'am.
41.
Yes, ma'am.
Documents.
Yes. Leave certificate. No, leave certificate.
But a statement due to
What is this?
My lord, that the leave certificate where serial number 11, if I'm not wrong. I had marked with pen, madam.
No, that is blank.
No, that I was not given. I had not taken it, but this permission that we carry our liquor with us. Had I applied because the statement of the witnesses also say, we know he drinks, but we have never found him in an intoxicated condition. Is every witness's statement. These are the documents of the inquiry, my lord, which I was given copies of during the inquiry. That will be available in.
We don't want to keep the entire bunch. You give us the relevant.
The records
copy.
are there for the record.
Relevant copy. All right. Then
I will bring this on record. I will settle. Yeah, I got it.
Yes. We list it on.
Lordship's convenience.
Hmm?
Lordship's convenience. I am doing.
Yes, madam.
Article 20.
This Saturday I have dependent, it's up to you, Lordship.
23rd then. 23rd.
Yes, ma'am.
November. For for further hearing. We'll try to dispose it off on that day.
So far as my plea of guilt, my lord, that I'll answer with the
Hmm?
the plea of guilt that has been shown, my lord, that I will answer with the judgment of this honorable court only. So that will not be taken into account.
On that day, record will, my lord, record. On that day, I'll submit the record, man, or today, my lord. If today, then I can, my lord.
You furnish the records on Wednesday.
Yes, ma'am.
Give it to the court master.
Yes, sir.
Yes.
Obligation.
Further hearing.
Further hearing.
Huh? Further hearing. कोई भी नहीं। Yes, yes, yes. Tell us.
Their disciplinary proceedings are still conducted under the old AACB General Service Regulations. Economic.
Disciplinary proceedings are
Under the old regulations. They have not changed.
under old regulations. Page number
14 years old. The power of suspension is there in the at page 14.
So you were suspended on?
He was suspended on
27/2023.
Huh?
27/2023, your lord.
Page number?
The last page, page number 20, your lord.
Okay, so what are your instructions?
My instructions are that the materials in the inquiry report reveal that perhaps we may not have enough materials to proceed with the disciplinary proceedings. But since there is a specific complaint by a female officer, so perhaps we'll have to constitute the internal complaints committee under the Sexual Harassment Act. For that, your lordship, section 12 of that act will come into office.
That is no specific allegation, lordship. That is only you.
Get your concrete instructions by Monday. We can close it.
Your lordship, my instructions are that the definite instructions are that the order has not been reviewed and extended. So
Only
Ah.
only the lordship disciplinary proceeding has been conducted, consisting with the three members, lordship, who two were junior than me, lordship.
Disciplinary proceedings conducted,
And lordship, no charge has been framed against me as of
not conducted as yet.
So lordship, I was paid before the authority, lord, and consisting with the three members, lord. As
That
on
must
today-
be the preliminary.
Preliminary stage, lordship. As lordship, as per your lordship, the Assam Service Discipline and Appeal Rule 1964, Lordship. That is the Rule 6121, Lordship. That is clearly mentioned, Your Lordship. The appointing authority or any authority to which it is subordinate to any other authority empowered by the government in that behalf may place a government servant under suspension. Only there are the two conditions, Lordship. Number one, Lordship, where a disciplinary proceeding against him or contemplated as in pending. Number two, where a case against him in respect of any criminal offense involving moral turpitude is under investigation or trial, Lordship. So, Lordship, Hemond has already expired, Lordship. So, no charge has been framed, no inquiry officer.
You show us
has
the
been-
judgment, Ajay Chaudhary.
Yes, Your Lordship. Ajay Kumar Chaudhary, that is clearly indicated that, Your
Paragraph.
That is clearly mentioned that within a period of 3 months, Lordship, the disciplinary proceeding should be concluded, Lordship. And failing, Lordship, he immediately will reinstate the incumbent, Lordship. By compliance, the CRPC provision 167 subclause 2, Lordship.
Heard learned counsel for the parties. This writ petition is directed by against the order of suspension dated 27/07/2023, whereby the petitioner was placed under suspension pending trial of departmental proceedings on account of his misbehavior with office staff being under influence of alcohol in the office premise and conducting himself in a manner unbecoming of his position as the assistant general manager. Stop. This order of suspension was issued by the managing director of the respondent corporation. Is it company?
It's a company.
Respondent company. Stop. The grievance of the petitioner is that no disciplinary proceedings has been initiated and the suspension has not been reviewed. More than 3 months have been passed since the order of suspension has been issued. Learned counsel for the petitioner has relied upon the judgment of the apex court rendered in Ajay Kumar Chaudhary, reported in 2015 7 SCC 291. It is the submission of the learned counsel for the petitioner that both under the Assam Discipline and Appeal Rules 1964 as well as read with the judgment of the apex court, the charge sheet is required to be issued by the disciplinary authority, pursuant to which the petitioner ought to have been entitled to file his response, and thereafter the department is required to take a decision whether to proceed for disciplinary action and against the petitioner. Stop. However, since the date of his suspension, no such steps have been taken by the authorities concerned. He therefore submits that the order of suspension, having not been reviewed beyond 3 months, in view of the ratio laid down by the apex court in Ajay Kumar Chaudhary, the suspension order ought to be interfered with and set aside. Stop. Mr. K.P. Pathak, learned counsel for the petitioner, for the respondent, submits that there is an internal inquiry, preliminary inquiry conducted, and in terms of the findings of the preliminary inquiry, the department is contemplating to take necessary action against him uh, as per provision of law, if required. Stop. However, he has fairly submitted that since the date of the order placing the petitioner under suspension, the suspension order has not been reviewed by the competent authority till date. Stop. There are learned counsels for the parties have been heard. The respondents have not filed a response. And the pleading, which is the writ petition, is being perused. And the submissions made by the respondent counsel have been taken note of. Clause 10 of the, what is this called?
This is called the Assam State Electricity
Assam
Board.
State Electricity Board within bracket General Service Regulations.
1960.
Is it General Service?
General Service Regulations 1960.
1964.
60.
Is being relied upon for the purposes of initiating disciplinary
I beg your
proceedings
pardon,
and
Lordship. There is another bracket for officers.
imposition of punishment.
The name is
Disciplinary
Assam State Electricity Board General Service Regulations for officers.
for officers within bracket 1960. Clause 10 refers to the disciplinary action and punishment to be imposed. Stop. The various misconducts, the various acts or omissions which will be treated as misconduct are also prescribed in the same clause. Stop. Although there is no provision for review of the period of suspension, the authoritative finding of the apex court in Ajay Kumar Chaudhary Supra will be applicable. Stop. The authorities are required to review the suspension periodically, not later than a period of 3 months from the date of issuance of the order. That having not been done, the order of suspension dated 27/7/2023 shall be deemed to have lost its force. Stop. The petitioner, the respondents are accordingly directed to reinstate the petitioner and release all his pay and benefits. Stop. This order shall not be construed to be a bar for proceeding against the petitioner under the provisions of the ASCB General Service Regulations for Officers 1960 regulations, read with the Assam Discipline and Appeal Rules 1964.
Those rules are not applicable.
Huh?
Those rules are not applicable.
Why?
We otherwise adopt the CCS Discipline and Appeal Rule.
Regulations 1960 or any other provision adopted by the authorities to proceed against the petitioner as per provision of law, if permitted. Writ petition accordingly stands allowed, disposed of in terms of the above.
Obliged.
Highly obliged.
May I please, your Lordship? Lordship, I have contact Mr. AJ Das. He is out of station, Lordship.
Who is Mr. A.J. Das?
Standing Counsel of respondent number 328, Lordship. This is branch manager.
Do you recollect his first name? He is out of station.
Yes, Lordship. After 1 week, he will be available.
After 1 week.
Yes, sir.
All right, we'll keep it on 30. List on 30 November as it is submitted that the standing counsel for the, what bank is that?
Is it as or
What is the name of the bank?
bank?
Indian Bank
Indian Bank, Lordship.
is out of station. MS so and so appears for the petitioner. Yes, yes.
This matter primarily pertains to certain adverse remarks in my APR, for which Lordship my subsequent promotion was denied. More particularly, the APR for the year 2010-11. Lordship, the petitioner before your Lordship.
Yes.
Lordship, he has joined as a probationary officer in the United Bank of India in December 1985. Lordship, subsequently, he was promoted to the middle management grade scale 2 in 2001. Thereafter to senior management grade scale 4 in 2009. Now, Lordship, the next avenue which was available to him was senior management grade scale 5, that is in the rank of assistant general manager. Now, Lordship, during that point of time, his case was not considered on the ground that he did not meet the benchmark score in the APR, that is 60. Thereafter, Lordship, we had approached this honorable court, Lordship. The order is at page, Lordship, it starts at 109, relevant is at page 120.
That period where you were a trainer, no ACRs are maintained.
Lordship, ACRs were maintained, but APRs were maintained, but the conclusion which they have drawn is that is on record, Lordship, that my performance in the training school might have been good, but my erstwhile performance as a branch head were not satisfactory, and therefore my subsequent APR was downgraded. However, Lordship, while I was serving as the branch head, the APR maintained, those were very good.
The bank has maintained a bank stand is 2008, 9 and 9, 10. APARs were not available.
Not available, Lordship. But Lordship,
so you, according to the petitioner, he was posted as a trainer.
Lordship, and in the impugned order, Lordship, they say that from 2006 to 2012, they have considered all the APRs, which means that 2008, 9 and 9, 10 were also considered. But thereafter, before the CIC, they say that those were not available. Now, if those were not available, the question of consideration cannot come.
Yes, Mr. Dr.
Lord, I will take your Lordship first. The page 55, my Lord. The intercy scale promotion process from the officer scale 4 to scale 5. Lordship will find that at page 55.
Yes.
Lord, your Lordship will find there are two eligibility criteria at page 56. The first is, your Lordship will find in the right-hand column, the competent authority has allowed 1 year relaxation in minimum experience for the current process, and all those officers.
You're referring to page 55.
56.
56. Yes.
Eligibility criteria plus 3. In the right-hand side, extreme right-hand side, number 1, you will find. This is the first eligibility criteria. The competent authority has allowed 1 year relaxation in minimum experience for the current process. Hence, all those officers who have completed minimum 2 years of satisfactory service as on 1/4/2012 in SMG Scale 4 are eligible to apply. This criteria he has satisfied. Now, Your Lordship, then down below, Your Lordship, see for promotion from Scale 4 to Scale 5, only such candidates are eligible to participate in the promotion process who have passed that scored minimum 40% marks in computer literacy test organized by the bank through IBPS on 22/4/2012. Now, the selection process. Selection for promotion shall be made on the basis of on-the-job performance and group discussion and personal interview. Only those candidates shall be called for group discussion and personal interview who have scored minimum 60% marks in APAR, that is Annual Performance Appraisal Report. For each, Your Lordship, kindly see the language, each of the years of service required for eligibility for promotion. This is the second eligibility criteria. My Lord, you will have to get 60% marks in each of the years under consideration. Now, this is the second eligibility criteria he did not satisfy. He, in the year, my Lord, Your Lordship may see that at page 131. We are concerned for 2010-11 and 2011-12. Now, 2010-11, he has got 59 marks. He is short of 1 mark. He is required to get 60, whereas he has got 59.
Yes.
Lordship has seen that. At page 131.
Sorry, 131.
My Lord. The grand total in the right-hand column, down below, Your Lordship will find 59.
Yes.
Now, we are concerned with 2 years, that is 2010-11 and 2011-12.
This
11-12
this is for
okay.
which year?
Yes.
This is for which year?
This is 2010 and 11.
10, 11.
My Lord. His marking is 59, is short of 1 mark. And therefore, he was found is not eligible to get it. Now, although, my Lord, in the 2011-12, he got 95 marks. But then since each year he is required to get the minimum mark, that is 60%, on that count, he was out. Now, he could not satisfy that clause.
Then another period, 2 years.
That is, my Lord, at page 2000. My Lord, 144. This is for the period 2011 and 12. He has got 95% marks. There he is okay. Look, the assumption of the petitioner is that he might have secured more than 60% marks. Now, my Lord, is a rank speculation only. Your Lordship may not embark upon but for assumption. This is just an assumption, my Lord.
How many years are required?
2 years. And Your Lordship
No. How many years are necessary for consideration?
For 2 years, my Lord. And that's the reason this Honorable Court also, my Lord, if Your Lordship see the High Court judgments at page 109.
So where is the prescription under the regulation, the selection process? Page 56.
Page 56, my lord.
So selection for promotion,
Selection for promotion,
60% mark for each of the years. So how many years?
2 years.
Where is it available?
My lord, this condition 2 years.
Huh? 3 years of satisfactory service is the experience.
For being eligible for promotion to scale 5, the candidate should have been a branch head for at least 3 years officer. Then, for being promoted to scale 7, the officer should have been regional circle head or must have worked in scale 3 to 5. That's for 7, my lord. If your lordship look at 1.2.6 as promotion scale 4 and above, for promotion from scale 3 to 4 and 4 to 5.
No, from which part, which page?
This is, my lord, the promotion scheme, revised promotion policy for the officer.
Page 39.
No, thank you. One point 2.6.
Yes.
For promotion from scale 3 to 4 and 6 to 5, it will be mandatory to pass an examination test for computer literacy and computer knowledge. For being eligible for promotion to scale 5, the candidate should have been a branch head for at least 3 years. Officers recruited for specialist cadre would be required to have field experience in a branch or as branch head. In case of officers in specialist cadres, this requirement can be complied with over the next 3 years, beginning with 2013-14, when experience of 1 year and 2 years for the year 2014-15 would be necessary.
So this is a promotion for?
From scale 4 to scale 5.
Scale 4 to scale 5.
Yes.
So you must be a branch head for 3 years.
My lord.
At least.
At least, my lord.
So how many years he was a branch head?
Branch head, my lord.
That is at page 125 from 2004 to 2009.
Page number?
Page 125, lordship. Guwahati branch was from 2004 to 2007, and thereafter Nagaon branch from 2007 to 2009 July.
Some pages are missing in my repetition.
What is a senior manager and a branch head? One and the same.
Branch head in the branch, lordship. Lordship, in the branch, lordship, the senior manager.
No, the requirement is branch head.
Lordship, yes.
Branch head.
So branch head is equivalent to, or a senior manager is equivalent to branch head.
Yes.
My lord, I'll have to look into that. These 2 pages are missing in my brief. Okay. Yes.
So these issues were already settled in the earlier round of litigation. Wherein the court-
Uh-huh.
These issues were already settled in the earlier round of litigation, wherein this court specifically directed that only discussion.
Please repeat
Lordship.
loudly. Yes.
Lordship, these issues in the earlier round of litigation, this honorable court has specifically categorically stated that resolution of the second issue, that is with regard to the entries in the APAR, would provide a solution to the entire dispute. And therefore, Lordship, consideration of those 2 years APAR afresh was directed.
My lord, Lordship may see page 121. We're required to see only for the year 2010-11 and 2011-12. At page 121, paragraph 25. That being the position and having regard to the law laid down by the apex court, the following directions are hereby issued. Entries in the APR of the petitioner for both the years 2010-11 and 2011-12 be communicated to the petitioner within a period of 30 days from the date of receipt of a certified copy of this order. Petitioner may submit representation before the bank against such entries within 30 days from the date of receipt or communication of the entries in the two APRs by him. Such representation of the petitioner shall be considered by an authority of the bank who is placed higher in office than the accepting authority. Consideration of the representation shall be done fairly and objectively, with an open mind and by the higher authority within a period of 2 months from the date of receipt of the representation. Decision taken on the representation shall be communicated to the petitioner. Once the above exercise is completed within a period of specified, and a petitioner attains eligibility, you'll also kindly see this wording. If petitioner attains eligibility, bank shall hold a review DPC to consider the case of the petition for promotion to senior management grade scale 5 along with a batch of respondent 5 to 49 within 2 months of completion of the exercise covered by direction 1, 2, 3. Now, my lord, obviously, as your lordship has seen the promotion policy, he must have been, my lord, eligible. Now, the criteria is 2 criteria. One, he is okay. So, the second criteria of eligibility is out there. Because each year he is required to get 60% marks. Whereas in 2010-11, he got only 59%.
No. So what is how many years is he required to serve?
Now, the direction is where to give him the.
No. This direction culminated because for 2 years he was not aware. As per your requirement, as per the rules, what is the eligibility? For how many years it is
So
necessary?
how many years were required to give him?
No, for how many years he has to occupy the satisfy the requirement of being a branch head or something for how many years?
3 years, Lordship.
3 years. Out of the 3 years, 2 years APR were not given to you.
Lordship, out of 3 years, Lordship, by their policy, they had relaxed qualification of 1 year and they said 2 years will be considered. That is at page 56.
That's the relaxation I have shown to your lordship. At page 56.
Yes. Then?
So, Lordship, 3 years, but 2 years was required to be considered. Accordingly, 2019 and 10-11 were taken into account. 2009-10 and 2010-11 were taken into account.
No, 19, no.
Sorry, 10-11 and 11.
10-11 and 11.
And 11. Now,
Because of the relaxation, my lord, it has come down from 3 years to 2 years.
2 years. So these 2 years period, you did not
I was
score 60%.
no, for 2010-11 I did not score. 2011-12 it was 95.
So what is wrong in the order?
Yes, Your Lordship. Now, if I may take Your Lordship to the APR, Lordship. Your Lordship will kindly see one aspect, the impugned order, that is at page, the relevant at page 153.
Yes.
Your Lordship will kindly see at the bottom, page 153 at the bottom, Lordship. I have seen the past performance and performance in the branch. Maybe in trading college he has done good, but as branch head his performance was not so good. And marks allotted are fair and without any prejudicial bias. Now, Lordship, now, Lordship, for that, for the since 2000, during that period, Lordship, since 2009, Lordship, I was not a branch head.
Where is that finding?
Lordship, page 153, Lordship.
No, 153 is extracted from which APR?
10-11, Lordship. After the communication of the APRs to us pursuant to the order of this Honorable Court, the APRs were communicated, we had preferred representation. Thereafter, this order was issued again.
You are referring to an observation by the authorities at page 153.
Lordship.
This is an observation made where? In some APR?
Lordship, in the 2010-11 APR, I am unable to find it, Lordship, anyway. But in the 2010-11 APR, which I have annexed, Lordship, it starts from page 125. There, Lordship, I am unable to find any such comments. That's been the APR of 2010-11, which have been annexed. But there no such comments have been made. Therefore, from where this
Yes,
observation
Mr. Doctor.
I cannot.
This 153, this appears to be
an extent.
This is an observation made in a representation which was disposed of.
Yes.
Now, while disposing of, there is an observation that his performance as branch head was not so good.
Yeah.
For which year is it? 10-11.
10-11.
So in the 10-11, where is the 10-11 APR?
Lordship, that starts at page 127. Lordship. 125 and 126 is my self-appraisal. 127 the APR by the authority, the grading.
Right from page 124, madam. 127, you may see.
Yes. It is very good, satisfactory, good.
Your Lordship will kindly see the interesting part here. Good and satisfactory are marked. Good is marked below satisfactory. Good is marked satisfactory. Your Lordship will see column number 2.
Don't unnecessarily detain the court. You have to now, first you satisfy us. So what is the requirement?
The requirement
is for 2 years.
2 years.
Out of the 2 years, in 1 year you scored
95.
95. In the other you scored 59. So now you tell us why, what is wrong in the order rejecting it, saying that.
Lordship, your Lordship will kindly come to the APR, the marks allotted to me. Lordship, I am short of 1 mark, Lordship. Your Lordship will kindly.
Yes.
Page 127, your Lordship will kindly say, satisfactory has been allotted 6 marks and good has also been allotted 6 marks. And thereafter, Lordship, again satisfactory, they allowed 7 marks. Page 127 itself. Lordship will kindly see the second column, quality of judgment and decision.
7 marks.
The quality of judgment and decision, Lordship, row 2.
Sorry.
Second row. Lordship. They marked me as satisfactory and the mark allotted is 6.
6.
Lordship. Thereafter,
Yes.
Lordship, third row, introduction of innovative improved system work, they mark me as good. The next row. And the marks allotted is also 6. So satisfactory and good, they have kept it in the same pedestal. Page 127.
Lord, can this be the subject matter of judicial review? This is the, my lord, the expert authority has given the marks. In what way then was best?
You are in this writ petition, you are challenging the order dated 11 December 2014. This 11 December is an order passed by whom?
Order passed by the general manager.
Appropriate authority.
The direction was that the representation be considered by an authority higher than the accepting authority.
Where is your representation?
Lordship. That is at page 146, Lordship. It starts from page 146.
So on this representation, the order of 152 was passed.
Lordship.
Now in this representation, where have you urged that the satisfactory and good have been awarded same marks? Or satisfactory has been awarded 2 different sets of marks, which you are now raising. This 147 is a representation where you have stated that in these circumstances, your performance ought to have been upgraded. There the authorities have rejected. But you nowhere said, nowhere submitted that for the same grading, different marks are awarded. Therefore, that has created a confusion.
Categorical statement is not there.
Then it is unless this specific statement is made, where is the scope for the authority to return a finding, which you are now raising?
That is there, Lordship, but 2 gradings cannot be put on the same pedestal.
You have not urged before the authorities. In spite of a liberty given by the court, you filed a representation.
But when thereafter, Lordship,
You did not urge.
understand.
On the basis of your representations, the authorities have given a return a finding. Now you are coming before the court and urging this.
Understand, Lordship. However, another aspect of the matter is that the finding which has been given that my past performance as a branch head, that in my humble submission cannot be taken into account for a subsequent APAR. Because at that point of time, 2010-11, I was never the branch head during that period. So my past performance as a branch head, that cannot be taken into account for arriving at this finding, because this honorable court directed that the review should be done in a fair and objective manner. My past performance was at the very inception could not have been taken because review was only to be done for 2 years. Even then they traveled beyond that very well, Lordship. And now the past performance was brought in to negate my performance of that year. That in my humble submission could not have been done, Lordship. Because, and moreover, Lordship, on the basis of my past performance, I was already granted promotion to scale 4 in 2009. So, on the basis of APRs, based upon which I was already granted promotion, subsequently they come up and say that your performance was not good and we are therefore downgrading your subsequent APR. Lordship.
Sorry?
Lordship. Lordship, 2009, Lordship, if you are Lordship, the finding, Lordship, that my performance in training college might have been good, but my performance as branches was poor. Now, Lordship, 2000, I was not the brancher during the period when this APR was prepared for, that is 2010-11. So, Lordship, bringing in APR, my performance, erstwhile performance, during my tenure as branches. During my tenure as branches, the APRs for those years were always very good. They bring, based on those APRs, Lordship, in 2009, I was promoted to scale 4. Now, when the time comes for my promotion to scale 5, the authorities say that your performance was branch head was not good. And 2010 to 11, Lordship, I was nowhere the branch head. So they bring in my past performance, for which I was already marked very good, and I was granted promotion on that basis. That could not have been taken into account for my for the preparation of my APR for 2010-11.
Yes.
Because during the period of 2010-11, I was never the branch head. I had always served as the branch head up to July 2009. So this contention with the observation that my branch head performance was not good and therefore my APR is correct, that's marking on my APR there in my humble submission is forward, sir.
On what basis are you submitting?
Lordship, because I was never the branch head during that period of 2010-11. And they say at page 152 that my past performance as branches was not very good. Was not so good, and therefore the marks allotted us are without prejudice. My past performance was already taken care of in my erstwhile APR. And based on those APRs, in 2009, I was already promoted to scale 4. Now, basing on certain APRs, I was already promoted to scale 4. Subsequently, they say that no, your performance was not good, so the subsequent promotion will not be available. The marks are fine. Because during this period of 2010-11, I was never the
all these you had urged earlier before the court, pursuant to which the court disposed of, issuing a slew of directions. And on the basis of these directions, the representation was disposed of. You preferred a representation there, isn't it?
Yes.
So,
that is what I am trying to submit to your lordship, that the observation that they have made that my past performance was not good, that could not have been taken into account because this honorable court had restricted the scope only to review of APRs of 2010-11 and 11 and 12. And during 2010-11, I was never the branch head. So the conclusion which they have drawn that my performance as branch head was not good could not have been taken into account in 2010-11 because I was never the branch head during that point of time.
yes.
Because court had specifically stated that these 2 years are to be considered. They had went beyond the prescribed category that which this honorable court had directed, and then they come to this perverse finding.
Anything else?
Lordship, and another aspect is, Lordship, in the API, they state that my self-appraisal was reasonably accurate. Now, as per my self-appraisal, I was in the grade of very good. So, having made an observation that my self-appraisal was reasonably accurate, thereafter, Lordship, that could not have been a contradictory finding that I was not very good and it could have been good, and that could not have been done.
Okay. Mr. Doctor?
My lord, there only in the representation they have said for upgradation of your APAR for the year 2011, 10-11.
But what do you say regarding his submission that you have taken his earlier performance?
Well, earlier performance
Why is that
my lord,
necessary?
if they have gone to it, it is immaterial, my lord, for the purpose of this case, in the sense, my lord, we are required to show what marks he has got in 2010-11, 2011-12, because in terms of the rule, my lord, he in every year he has to get 60% marks.
Oh,
In a
that we
given
agree.
year,
That we agree.
my lord.
Now, in terms of this impugned order is passed pursuant to the directions of the court.
Exactly.
Certain directions were given.
My lord.
You were supposed to examine and pass orders.
Yes.
But you make a reference to his earlier orders, earlier performance.
That was, my lord, it was not necessary at all. My lord, if they have gone also, it is not at all, my lord, relevant for the purpose of this case. Because here we are concerned with 2010-11, 2011-12. And if they have gone.
And secondly, in the 10-11,
yes,
you find that the gradings carry different marks.
Yes, that can be, my lord.
How it can be?
Your lordship can
satisfactory, you have given 6 marks, again 7 marks.
My lord, that is the expert committee. They know it better.
No, the expert committee must indicate that satisfactory will range from X1 to X2.
My lord, how they allot marks, I don't have any idea. But so far, this much I can say, my lord, is the doing of the expert only. So in a, my lord, I just say that in a judicial review matter.
No, what if the experts go wrong?
Yes, my lord.
So how to decide whether they correct or wrong unless we know on what basis, what reasonings?
That for that reasoning, my lord, we shall have to ask them how we have done it. They will have to call for.
So if there are no reasonings, then we'll have to presume that there are no reasons. This is arbitrary. What else can we hold?
My lord, I don't think it can be said to be arbitrary. They haven't said that it is arbitrary. In their repression, they have accepted that in a given year, 2010-11, I was allotted 59 marks. So it should be upgraded. Now, upgradation is not automatic, my lord. It's not up to, otherwise, my lord, what will happen? There may be some other candidates also. They have.
We are not in all this. We are not even transgressing into your territory of allotment of marks.
Yes.
We are only trying to see their allegations that whether any interference is necessary. Number one, in the order which is impugned, there's a reference of past performance, which has already been acted upon.
Yes.
Earlier.
I can understand.
The second is that this particular gradings which have been given, these gradings on the face of it appear to be little confusing because for satisfactory and good, you are allotting the same marks at one stage, page 127.
My lord, that how they allot marks, my lord, I will have to interact with them. But then I can show your lordship certain thing. Your lordship.
Against this, what representations did you file?
Lordship, the representation at page 146, because those were not communicated to me.
146.
It was communicated only after directions of the committee. And Lordship, another aspect, Lordship, if I may kindly.
Wait.
Lordship,
Come one by one. Come one by one. Don't rush. This 146 representation is the representation on the basis of which this impugned order was passed. All right. Yes. Tell me what.
Lordship, at page 129, if your Lordship may kindly turn to page 129. Second row, Lordship. Second row, Lordship. Leadership integrity, Lordship. Page 129.
Second.
Lordship, yes. Second
Yes.
row, Lordship.
Yes.
Leadership integrity. Lordship will kindly see, I have been allotted 3 marks. Your Lordship, in the second column, it states integrity, and in bracket, in case of adverse views, please specify. So no views has been specified that there is anything adverse against me. However, I have been granted 3 marks. The authorities themselves have stated that adverse views must be specified. There is no specification.
Yes.
My lord, if your lordship will look at page 127, 2010-11 period, the mark, how it has been marked, very good, capable of executing, discharging the job independently, does not need much supervision, but needs more penetration in tackling defaulted borrowers of all segments. Thereafter, my lord, satisfactory, sometimes apprehensive, which result adversely affected. Now, therefore, my lord, these are the things which has been found is lacking. Ultimately, my lord, he could not score 60% marks, slightly short of scoring that.
Yes. Now, what is the extent of judicial review insofar as?
Lordship, my humble submission is that this honorable court has directed for review of 2 years APRs in a fair and objective manner. That was specifically directed. Now, the authorities, they went beyond that on their own effort. And then they come to a finding that since your past performances, branches were good, and on that ground, they try to justify the markings of 2010-11. That, in my humble submission, is perverse. Because on the past performance, I cannot be judged for a subsequent year. This honorable court has directed a review of that particular year itself. They went beyond, and then they try to justify the APR of 2010-11 based on past performance.
Yes.
That is my primary contention. Secondly, Lordship, it is, Lordship, a same grading satisfactory on both counts. On one count, Lordship, satisfactory contains 6, and the another grading, good, also contains 6. That cannot be, Lordship, because in every APR, Lordship, both are on different pedestals.
Yes, yes,
so,
yes.
So satisfactory and good, they have kept it on the same pedestal now. Therefore, if that be so, my learned senior will have to justify that in the United Bank of India, satisfactory and good means one and the same. However, Lordship, that cannot be contended because immediately subsequently, they again rate satisfactory as mark 7. So their very marking system is flawed.
Why should the court go into all this? For what purpose? Whether it is 7, whether it is 6, why should we go into all this?
Lordship, because Lordship, on the face, in my humble submission, Lordship, on the face of it, this APR was not maintained in the manner it was required to, because this was done to oust me from my promotional avenue. Because, Lordship, all along my APRs were very good. Now, suddenly, in 1 year, I become so apprehensive.
So I'll just highlight paragraph 11
of this judgment. Yes. Yes.
It's a well settled principle of service jurisprudence. So the employer is entitled to lay down policy decision, laying down the criteria for grant of promotion to its officers. The eligibility norms for such promotion must be defined by the bank on a realistic basis, wherefore a system to choose the best available talent to man the critical position to be devised. Once a power vested in an authority by reason of the provision of a statute is tried, that such power can be exercised from time to time. Changes are required to be made keeping in view the requirement of the management as also the exigency of the situation obtaining at the relevant time. Furthermore, it is one thing to say that by reason of section 19, the Parliament has conferred essential legislative functions upon the Board of Directors to make regulation, but it is another thing that to say that the regulation is arbitrary and ultra-vires as it did not contain sufficient guidelines. The High Court did not come to the conclusion that essential legislative competence of the Parliament has been delegated to the Board of Directors in terms of section 17. Then next, my lord, 2019 6 SCC, page 362, paragraph 9. I will just read out and I will hand over this judgment to your lordship. Paragraph 9 speaks. The essential qualifications for appointment to a post are for the employer to decide. The employer may prescribe the additional or desirable qualifications, including any grant of preference. It is the employer who is best suited to decide the requirements a candidate must possess according to the needs of the employer and the nature of work. The court cannot lay down the conditions of eligibility, much less it delve into the issue with regard to desirable qualifications being on a par with essential eligibility by an interpretive rewriting of the advertisement. Questions of equivalence will also fall outside
There
the
is no
domain of
quarrel
judicial
with this
review.
proposition. Sorry to
My lord,
interrupt.
in the proposition.
There is no quarrel. That employer has the right to lay down
Exactly.
eligibility criteria.
Now, therefore, he is falls short of one criteria.
Question is, what is the meaning of effective evaluation?
Right.
And
The
to what
evaluation-
extent, if permissible, is judicial review permitted?
My lord, here the marks has been given.
There is no question. There is no question of interfering or finding fault with the department that you have 2 years or 3 years of APR or that many
Right,
number of
right.
years. Nothing of that sort.
Yes, sir.
This impugned order is against an application filed for review of these markings in the APR.
Exactly, my lord.
For giving a effective evaluation in terms of the directions of the court.
Right.
Now, whether in terms of this direction, was it done or not?
Yes. In my respectful submission, he has given the marks.
The judgments, with all respect, you are relying on is with regard to eligibility criteria. We are not, there's no quarrel
Exactly,
on
my
that.
lord. And your lordship has seen in the order passed by this honorable court, they did not go into that also. And therefore, they did not challenge that part of the thing. But in abundant caution, my lord, to make the position, my position clear.
That is not even an issue here.
Exactly, my lord. I'm exactly with your lordship's what your lordship has said. Now, only thing, lordship has seen the performance report of 2010-11. He has received only 59 marks. Fallen short of 1 marks, it is enough to oust him. So therefore, it cannot be said it is the marks have been given arbitrary.
No, the question is, whatever marks in whatever manner has been given, is it entirely the domain of the authorities? Is judicial review absolutely not permissible?
My lord,
or is it a case in a given facts and circumstances in a case like this?
I will not say that.
More particularly when there is a direction of the court
My lord.
to give an effective evaluation.
Yes.
Whether that was done or not. If not, what orders can be passed?
Yes, it is. It has been given by my lord what he has to receive, and the appropriate authority, who are the expert committee, my lord, they have given the marks. And my submission would be that they want an alteration of these marks. Instead of 59, it should have been 60 plus. Now, in what basis that the court will look into that, and whether this honorable court can go into that?
That is what we are asking you.
My submission.
Your reply is a query that we have asked you.
My submission would be that, my lord.
Anyway, all right.
Beyond the scope of judicial.
We are keeping it for 5th for orders. 5th of December.
So final order. Much obliged.
Right.
Hello. Item number 27, could it be, my lord, on 12th of December?
It can be on any date. There is no difficulty, but every date is like this.
Doesn't matter, my lord, I'll try my luck that very day. Maybe I may be more lucky.
Item 27.
Yes, on 12th of December.
Rupchan, what is that?
Oh, no, that's a different matter, I believe.
That's a different one.
That's a different case. This is different.
27 on when you
12th
wanted?
of December.
12th of December.
Yes.
12th of December. All right. List on 12th of December, item 27, as requested for by the learned senior counsel, Mr. P.K. Tiwari. And who's for the other side?
I'm appearing.
Mr.
H.
Borgohain. H. Borgohain. Buragohain.
Buragohain.
Appears for the respondents. Yes.
That is, my lord, S.I. Ruplal.
S.I. Ruplal, that's right.
Now I remember that, but I don't know the date when that matter is fixed.
Lordship's permission, my lord, item number 28. Very short matter, my lord. My friend is also here, the respondent. We disposed of it, some date could be fixed, my lord. Young boy out of his service, my lord, for quite 22nd, my lord.
22nd, not possible. It has to be in December.
December, my lord, then, my lord, this 7th of December, my lord.
All right, 7th of December. 7 December, item 28.
I'm obliged.
Item number 30, my lord.
Hmm.
On the 7th.
Hmm?
Item number 30.
30.
Yes, right.
Yes.
APAR 7.
7.
Right.
7.
May I please, your lordship, in item number 29, lordship. Interim shall continue, lordship.
Hmm?
There is an interim. Interim shall continue.
Lordship may fix a date, it's a disciplinary proceeding matter, Lordship.
Okay, lordship.
All right, let it be on 7th December.
7 December. Lordship.
Interim order to be continued.
Problem.
Twenty-six.
Lordship, let it be any day after the 1st of December, lordship.
You pick your date. 12th of December.
That's fine.
12th of December. Right. That will be listed on 12th of December.